Good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session. I'm Joey Hargis, Metro Zoning Administrator, and I'll be going over the cases for today in public hearing. I know some folks come in. We've added some seating. If anybody does not have a seat or they just want to stand up, that's okay. I just want to make sure there's enough seats in the back if anyone needs one. Okay. We'll go through all cases set for public hearing today. The board on their agenda today has both old business and new business in front of the board, and we'll take the old business first. The board is invested to act of the powers force as outlined in section 1740, 180 of the Metro Code of Law. The board requires that have 4 members present to constitute a quorum. We have 5 members present today. I have two members who are absent. And the board will then discuss and vote on each case before you in the public hearing. The procedure will be to introduce the case record as the Codes Department has, and I'll do that on the wall in front of you by means of a PowerPoint presentation. To your right, when you get ready to come give testimony to the board, there's 4 seats at a table in front of you. Just to the right of the microphone podium is a symbol for a person. If you'll click that symbol, your light will turn red, kind of like my microphone is. If you'll identify yourself and then make your presentation to the board. Once you get done speaking, if you wouldn't mind, just push that button one time to turn it back off. All right, Mr. Chairman. A couple preliminary announcements before we get started with any of our old business. We have one case today that has been postponed. And that is on the bottom of page 5. It's case 2024-97, Cesar Olave Del Refugio Enterprises, LLC at 444 Hicks Road. That case has been postponed till September 15th. New notices will go out for that case to the adjoining property owners, but that's case 97 at the bottom of page 5. Are there any parties present here for case 97 on Hicks Road? Okay, Mr. Chairman, seeing none, I think we spoke with just about everybody that we knew involved to let them know before that. So that case will not be heard today. It will be moved to our August 15th agenda. Okay, before we begin old business, the board has a consent agenda. And prior to the meeting, the board member reviews the case record and feels that the application meets the requirements of the code, and they don't feel that they don't feel that testimony would alter the material facts. The chair recommends the case for consent. I'm going to go through the cases recommended for consent, and if you're here in opposition to a case that is on consent, if you will raise your hand, please, we'll remove that case from consent and hear it in its regular order. Okay, the first case recommended for the consent agenda by Chairman Pepper is case 2024-81, John Hennessy, the owner of the property at 4500 Price Circle Road, requesting an item D, which is an addition to a non-conforming structure in the RS40 district. Are there any parties here present in opposition to case 81? Okay. Okay, Mr. Chairman. Seeing none, that case is recommended for consent. The next case recommended for the consent agenda is on the middle of page 4, case 2024-93, Mr. John Slaughter, appellant and owner of the property at 3297 Leland Lane, requesting a variance inside setback in RS10 to construct a screen porch. Are there any parties present in case 93 in opposition? Mr. Chairman, I see none. And then finally, the final case recommended for consent is the last case on today's docket at the back on page 6. Case 2024-98, L&S Development, owners in common at 28th, the owner of the property at 2719 Torbit and 1618 28th Avenue North. That's a corner lot. That's why there's 2 different addresses. And they are requesting a special exception to allow for street setback in CS. This has previously been approved by the board under cases 2019-251 and 21, case 120, their 2 years has expired, and that's why they're seeking reapproval. Are there any parties here in opposition to case 98 on Torbit? Okay, Mr. Chairman, seeing none, those are the three cases, just recapping, cases 81, 93, and 98 recommended for consent.
Move to adopt the consent agenda.
Okay, if you are here, let me just double check. I feel like I'm missing one. If you're here for cases 81, 93, and 98, you have been approved. It is necessary for you to follow up with the Codes Department beginning on Monday for your permits. Mr. Chairman, I think I may have one more I've left off looking back through my notes here on my computer. There is one I left off. I apologize. Mr. Chairman, you also had case 96, Mr. James Pfeffer, Tremont Properties, LLC, owner of the property at 1309 Gray Bar Lane, requesting variance and street setback to construct a new single-family residence. Are there any parties present to case 96 who are opposed on Gray Bar? Okay, members, seeing none, I'll need another motion for case 96.
I'll make a motion to place case 96 on the consent agenda.
Is there a second? There's a motion, a second. Any further discussion? All in favor? Okay. That goes on the consent.
Just recapping the consent then, we have cases 81, 93, 96, and 98. If you're here for any of those four cases, your cases have been approved. You are free to go. I will always wish you can stay and sit along with the rest of us for the next cases. But if you're here for those four cases I called, your cases have been approved, and those cases are completed. Mr. Chairman, before we begin old business, we do have a procedural matter we need the board to address, and our legal counsel is certainly here to address should you have any questions.
Sure, it's my understanding that email or letter has been submitted by one of the council members. And if you'd like to address that or open a public hearing, you could have a motion to suspend the rules and address that as the board sees fit.
So let me ask the board members, has everybody had a chance to review that email? No. Okay. It came in last night at 8 p.m., at least I was emailed it last night at 8 p.m. You should have a paper copy there. I'd say, I don't think it'll take long to review, but essentially the council person for that district is taking the position that it's improper for us to go forward with considering a variance because the applicant did not make a application for a variance, only for a special exception.
The only consideration that I would say is I think we probably have an issue with the fact that there were members who were present at the last meeting that are not here and are not able to review this in conjunction with it. So, I mean,
I don't know that creates an issue, because I think what the council person is asking for us to do is to open up, or basically she just objects to us hearing the variance. Right now it's tied up. There's been no decision on this case. There were three.
There's a pending motion.
We're going to have to vote on it again. So I will say I have reviewed the record. I'm satisfied that there was more than ample notice that a variance was being requested. The very first letter that the applicant submitted made it very clear that in addition to the special exception, they were asking for a variance. So I think the rule was complied with. If it wasn't technically complied with, I see absolutely no harm, because it has been from the very first meeting, I think in March or May, the applicant has made it clear that they are also requesting a variance. So that's how I would vote on it, but I'm glad if y'all want to open up the discussion, or.
No, I agree with you.
Okay. So does anybody see a need to open it up for discussion or take any action other than resolving this issue, which is right now we have to vote on again because the motion that was pending did not receive 4 votes? Okay, why don't we proceed to the vote then, Mr. Hargis?
Okay, Mr. Chairman. That brings us to the matter on the table. There's a motion to deny case 2024-17. Bard Civil Associates, Gladys Bond, the owner of the property, 4460 Ashland City Highway, 4309 Cato Road, requesting special exception and variance in street standing. The motion was made to deny the request, and the vote stands currently as Ms. Johnson, Ms. Carpenek voted to deny. Mr. Cole, he is absent today. Ms. Davis voted against the motion to request. Mr. Ransom, who abstained, is not present. That leaves Mr. Bradford. I'll poll you at this time. Have you reviewed the case record in this case?
Yes.
Okay. And do you wish to participate in this case?
Yes.
And what is your vote, Mr. Bradford?
My vote, my vote on the pending motion to deny is no.
Okay. Mr. Bradford, the record will reflect that your vote is against the motion to deny. Mr. Pepper, I'll ask you the same questions first. Have you reviewed the record in this case?
Yes,
Do you wish to participate? And if so, what is your vote?
I do, and I also vote against the motion.
Okay. So the motion votes are two in favor of the motion to deny, Ms. Johnson, Ms. Carpenek. The nays are Mr. Cole, Ms. Davis, Mr. Bradford, Mr. Pepper. That motion fails. Members, because we are beyond 30 days of the public hearing, we will need a new motion.
I will make a motion that we approve the application based on the fact that I believe a variance is warranted. Whether this road is a private road or not, I think both sides have made arguments. I don't think that needs to be addressed because I find that when the state or the authority that took this property took it by eminent domain, they cut off the access to Ashland City Highway. I don't think that's a self-imposed hardship. I reviewed the traffic report. I think, there will be some increased traffic, obviously, because of this construction, but I'm satisfied that it's not such that that a variance should not be approved. So I make a motion to grant the application based on the fact that there's a variance should be granted because of the hardship that I've just talked about.
I'll second.
Okay, there's a motion and a second. Any further discussion?
I understand your point of view, but I still disagree with that hardship. And because we have to think about special exception. And I would like to first establish special exception condition has not met on street standard. That's why you are considering variance. However, you say it's a special domain. I would agree with it if the church was there and the street was taken from the property owner. But this entity choose that particular parcel to locate the church to. So there's a choice. They don't have to go there. They could go with that, especially considering they want to have that large church. They could have. They could have chosen to the literally arterial street or to intersection of Collector Street. And this location is intersection of local street and private or T-dot access street. So to deviate from the special exception street standard condition is too large because the reason for special exception, depending on the church size, is the church up to 300 seat can be located in any street. And this church is minimum of 1,200 seat and looking forward to grow up to 2,000 seat. So that will produce more traffic. Unfortunately, Nashville does not have reliable public transportation. And if we do have park and ride, if we were to carry 1,200 people or 2,000 people, it will need at least 20 to 40 micro large coach buses. So that will produce that much traffic into those local streets. And if you really take a look at the traffic impact study, yes, if you look at the weekday combined traffic study, it may be only 3% plus 1%. So because, naturally population grows and traffic grows, so natural increase will be 3%. However, Sunday traffic, if you look at it, the volume increased 2,700% on that time period. And it would be 15 minutes, it would be 30 minutes, but it would be really inconvenient for the people who are living in that area. And I think it's a really adverse effect to the surrounding property. Also, at the last meeting, what we have not discussed is the size of the church building, because there is existing property right next to north of the proposed church building, and we have not discussed adequate landscape buffer. Yes, sea buffer is proposed, I believe, but we need to discuss what kind of light spilled onto that property or noise control. And I think it would be irresponsible for us to not even consider those effects bring to the existing neighborhood. So for that reason, I am the variance or hardship itself is not enough reason for us to approve. I think we should really consider, not only street standard, but also affect the church building and traffic will bring into that property. And one more thing I would like to, us to consider is Arupa, because it's a religious land use, Religious Land Use and Institutionalized Persons Act. So meaning we cannot bring,
Well, I don't
oppose unduly burdensome.
I mean, our LUPA would apply if we were denying it, I think would be the,
No, I think our LUPA will go both hand. The reason I'm saying is 2010, when new technology, LED sign was introduced, all church wanted to have LED sign, maybe not all, but major church jumped onto LED sign because it's more convenient. You don't have to go out and, use the sticker or, going up to the ladder, so to change the announcement. So that was a new technology, but many, many neighborhood people opposed it because there were in like a 1 mile circle, maybe 5, 6 churches. And if every single church going into the LED sign, that would be so bright and so obnoxious. So many, neighborhood people opposed it, but there was in the metro zoning what they call SP, which is specific zoning. And some people use specific zoning to only change zoning for 0.05 portion where the LED sign can be stand, because currently each stand LED sign is only allowed CS commercial zoning district. So that one year in particularly, one church wanted to have LED sign in residential zoning, that was RS zoning. And they wanted to change 0.05 portion of the land to SP to allow LED sign. Not only regular LED sign, but oversized and tall, and it's really even outside of the sign ordinance and what is allowed at that time. So planning director at that time, Mr. Barnhart, cautioned us, a looper, meaning if we were to allow those zone change to allow sign zoning, any application come follow that specific zone change. We must allow because we cannot only allow for the one church, not deny on the exact same condition to another church or a mosque or whatever the case might be. So that's the, a double-edged sword and both coin of our looper. So that's why I would like to really consider if our choice is a right choice, because otherwise we are superseding existing special condition street standard.
So my understanding of our LUPA, and maybe our council can advise, my understanding of our LUPA is that our LUPA is essentially a mechanism by which a religious institution would then make a claim that because that they are unable to worship or conduct their mission in the manner that they wish, should a zoning ordinance or something be strictly applied, that the sort of idea that it's, with respect to Ms. Johnson's concern, that if it happens here, it's going to happen every other time. Is my understanding of our LUPA correct in that essentially it's, we want to worship in this way, but having to comply with this zoning code is preventing us from exercising our religion in this way?
Right. So RLUIPA cases are very fact dependent, and so it's difficult to say off the cuff. And I could read you, let's see. So what the applicant coming here is showing you that there is a substantial burden on their religious exercise. And under Sixth Circuit case law, there are a number of factors that they look at that are very fact dependent. You're looking at whether the religious institution has a feasible alternative location from which it can carry on its mission, if it will suffer substantial delay, uncertainty, and expense due to the imposition of the regulation, and whether the religious institution has imposed a burden upon itself. For example, if it's acquired an interest in land without a reasonable expectation of being able to use that land for religious purposes. And then if they can show that substantial burden, then the burden goes to, that is using a different sense, the government then has to show that they have a compelling government interest and are implementing it in the least restrictive way. So it's very fact dependent. You need a lot of information and evidence if you're doing that kind of RLUIPA analysis.
Okay, so it sounds like it's somewhere between what Ms. Johnson indicated maybe and what I think it's what I'm hearing is that deciding a case one way doesn't necessarily mean that the floodgates become open. I think, as far as I understand, the way that the law would apply is that making a decision here, I don't think would make this something that has to happen with other churches because it is tied to the particular land at issue. So I think that if another institution came to us and said, this is what we want to do, I don't think we're bound here by what's decided in this matter. But maybe I think I'm right, but I'm not certain.
Well, I think you are too. I don't view us as being bound. It is very fact specific, and I don't know.
Yeah, and I've looked at and having watched the video, reviewed the full record and everything. I mean, I agree with the chairman on the issue of that I think that a variance is warranted based upon the sort of the T-Dot's taking that occurred. I think that the shape of a lot can be affected and impacted in a manner by, something other than what this institution is done. I do think that there is a legitimate question over the special exception because I think that there's evidence that's been presented in both directions with respect to the street issue. I am in support of a variance, but I am not necessarily in support of a special exception for this particular property. And so I think the motion on the table is for a variance, if that's correct.
It is, and I do need to ask for an amendment to it because I know when NDOT spoke,
Well,
they said that I'd like to add as a condition that the applicant continues to work with NDOT.
I was going to
meet their requirements.
I was going to put an obligation to comply with with any obligations that NDOT places on it. And I was also going to ask that we put that requiring consultation with the urban forester on a landscape buffer.
So I'll amend it to include both of those. Did you second it, Ms. Davis? Somebody seconded it, I think.
I did, and I just had one more condition, just based off of the testimony of the traffic study representative who was here at the last one. The church had already sort of committed that when they have services that reach a certain threshold of people, that they will always have traffic control, just to make sure the traffic keeps moving in that area. And I think since they've already offered that condition, we should mandate it. So the two conditions that you all added, and then I would add that one.
Okay, so I will move to amend my motion to include those three conditions. Okay, and you'll second that, I guess? Okay, all right.
Mr. Chairman, before you vote, I want to make sure for Christie and I are writing down the motion. Your motion is just on the variance and not the special exception, is that
My
correct?
motion is just on the variance.
Okay, thank you.
And it has three conditions that the applicant continue to work with and comply with NDOT requirements, that there be, what was yours, Mr. Redford?
That they comply with the conditions imposed by,
Urban forester.
Oh, and then the consultation and approval from the urban forester on landscape buffer.
Point of a question. Does church has right to build wherever? Don't they have to meet special exception? Because in our zoning code, we do not have specific code or zoning to allow church to be placed anywhere. That's why we do have special exception. So variance is on special exception. Because you cannot just ask for variance, because church has to meet the special condition to build on the residential zoning or wherever the zoning is. So that's the first hurdle they have to cross. And if they are not meet with those special conditions, with a land standard, street standard, church or any other institution cannot build according to our zoning, our codes. And so you cannot just approve the church based on the hardship and variance alone.
Legal counsel?
Yes, I'm in agreement. My understanding was that this is before you on the request for a special exception, and that the variance would be a variance from the street requirement. That was my understanding of what was before you.
So we would have to approve a special exception?
You would have to approve the
But
special
it-
exception with
okay,
the
but-
variance
but-
kind of contained within it,
Okay.
varying with a variance for the street requirement.
Got it, okay. Well, with that posture, because the variance applies to the street requirement, I think that was the one holdup for me
Right,
on approving it purely on special exception grounds, so that,
I mean, that was the holdup, period, with the special exception.
Right.
I mean, they met all the requirements
Right.
except that. So I can redo my motion to make it that we approve the special exception based on granting a variance with respect to the connection, the street connection, and add those three conditions that we've already, what was your condition, Ms. Davis? I'm sorry.
That, based off the traffic study, when the church has any event that triggers a certain threshold of people, that they have traffic control out there directing and managing traffic.
So if I may, there's a condition from our last meeting provided by TDOT that says the condition is active traffic control shall be required at the intersection of Ashland City Highway and Cato Road, and at the intersection of the proposed site access at Ashland City Highway based on the size and scale of any congregational event. The applicant engineer shall continue coordinate with NDOT to determine the appropriate level of active traffic control for various size event. And condition number 2 is the approval for the land use should be based on typical activities associated with a place of worship. any changes to the site or additional use that may be proposed in the future may be required to perform additional traffic analysis based on the opinion of the Metro traffic engineer. That was the condition sent to us by NDOT.
Right, and my
Yeah,
motion
Matthew
contains
Huttable.
a
So those-
condition that they comply with all NDOT requirements and anything, my motion is contingent upon them complying with anything NDOT wants them to do.
Yeah,
And that they agree to provide the
Yes,
essentially traffic control that they've agreed to, and that they agree to work with the urban forester. So those would be the three conditions.
if I may, I'm still not
Sure.
for that condition, but one of the traffic KCI technology says widen driveway to T-Dot driveway standards. That's the one of the condition they recommended for that access road or a private driveway or T-Dot access road. That was the one of the recommendation. So I think it's prudent for us to include that condition if you are to going into that section, because that literally, the current private driveway is, according to the traffic study, not wide enough. So that was one of the recommendation they put on that access.
Was that the NDOT recommendation or the?
That was KCI,
KCI?
yeah, traffic engineer's recommendation. It's
I don't have any
300
problem with
pages,
that.
Hey, I don't have any issue. The only reason I was hesitant about putting it as a condition is I don't know that to the extent that they have to get, if we say they have to do it and somehow TDOT has an issue with it, I don't want to put us in a position of having said one thing and then TDOT says another. So frankly,
You mean NDOT?
no, because I think this I think it's a TDOT road. And so it would need to be, yeah. So what I think I'd be comfortable with would be, complying with all recommendations contained in the traffic study, subject to,
Appropriate approval.
subject to appropriate approvals or, to the extent any other authority, basically with authority over and above us on this says no, then I don't think we can, that'd be sort of the caveat, I think. But
And I mean, I would think NDOT and TDOT, I thought it was strictly NDOT jurisdiction, but if TDOT's involved, I would think that they would look to this traffic study. And,
yeah,
I mean, I'm confident in NDOT and TDOT to, even if they didn't have that traffic study, to do their job and make sure that whatever it needs to be done is done. But I'm fine with including as a condition the things that the traffic engineers, the private traffic engineers recommended. I kind of agree with Mr. Bradford. I don't want to create a situation where NDOT or TDOT gets crosswise with what is in that report. Maybe they may want something more and then decide, well, since the BZA already said they just have to comply with this, we're not going to require more. So
I think, in my past experience, we do have to work with, and that has to always work with the TDOT, because many of the street in our city is, within the Davidson County, but owned by TDOT. So they do work together. And so sometimes we do, there's a railroad, so we do work with CSX. But in the condition of the approval, we place, the planning commission place condition of approval by CSX or condition of approved by TDOT. So that is, I think, is a reasonable condition. So if they can get approval of a TDOT, then, they should do that. Because otherwise, it would be not be fair to the neighbors, the narrow driveway, 50 minutes, 30 minutes, 45 minutes, they won't be able to get out from that driveway. That's a great concern to me. For that reason, I'm still opposed to it. But if you were to go that, I would like to consider that condition as well.
okay, your condition would be that the applicant comply with the traffic engineer's recommendation that road be widened?
Yes.
Okay. I don't have a problem with adding that as a condition.
Yeah,
So-
just maybe, yeah, to, you know, to the extent allowed by law, basically, I think would be the one kind of component that I would have. One question I did have, because this is if we approve this as a special exception, that would give the neighborhood the opportunity to, you know, seek a show cause if there were some sort of violation of the, so I think that is a very important thing just to note is that, you know, that there is recourse if there's an issue with anything that's been placed as a condition on this property.
Okay.
Thank you.
If you don't-
With that,
Sorry.
sorry.
I just wanted to clarify one more thing, just in terms of, you can phrase it in terms of the variance, that's how council has presented this case. In the ordinance itself, under new religious institutions, facilities, it says the Board of Zoning Appeals may waive the above street standards based on a recommendation from the traffic engineer. So you could phrase it in terms of like a waiver as the ordinance phrases it, or in terms of the variance, or you know, or alternatively. Just because that's
Okay.
how it was framed as a variance to the special exception, but the special exception ordinance itself allows for you to waive the street standards, given the recommendation of a traffic engineer.
Okay, so, I think I follow you there. All right, I'm gonna probably need to restate that motion, so, okay, so, I'm sorry, Ms. Johnson, do you have something else to say? I didn't want to cut you off.
Yes, I still want to state why I oppose Chairman's motion, because it is a variance from the special exception of street standard. So street standard in this size of the church is arterial or intersection of two collector street. And this case, variation requested was vary from two local street. I would be more prone to agree with the chairman's motion if one street were collector street and one is a public driveway or something in that case. But this case, both streets are local. So I think that's too much of variance and deviation. For that reason, I still oppose the motion. I just want to make it clear.
Okay, thank you. So let me, pardon, if that's somebody from the audience, we're not in public hearing right now. So let me restate the motion. I move that we approve the special exception that the applicant has sought with a variance for the road not being an arterial road. The conditions are that the applicant comply with all NDOT requirements, that the applicant comply with the KCI engineer's requirement for widening that particular road, that the applicant work with the urban forester and make sure that the urban forester is
Approves
or that the urban
approves any landscaping
forester
plans and
approves.
buffers.
Correct, thank you. Approves any landscape issues, and that the applicant, as they've committed to do, provide the traffic control resources, I'll just put it that way, that they've said they would provide it during particular times and events. Did I get all the conditions? I think I did. Okay, so that's the motion. Is there a second? There's a motion and a second. Any further discussion? All in favor? All against? Okay, so that motion does not pass 3-2. So what
Mr.
is our
Chairman.
situation, Mr. Hargis, since this is,
Under your rules, the request for this church fails by operation of law. The vote to grant is tied on votes, but under the board's rules, we're beyond 30 days of the public hearing, so this is deemed a denial.
okay. Okay, that's,
All right.
that case.
Again, just recapping, case 17 has been denied by operation of law. We will ask those parties who are present, if they wish to stay, you can. If you wish to depart, please do so quietly. Mr. Chairman, we'll move to our next matter.
Okay, next case.
Yes, sir. Mr. Chairman, if we would, just give these folks a minute to depart.
Before we call, let's let everybody clear out here. I think it's going to take a bit for. Oh, all right. Yeah, I may need that. Was somebody for the audience? Oh, yeah. Who was it? Were they yelling at me?
Ladies and gentlemen, I would ask if you all will depart. If you're here for case 17, go ahead and head out so we can continue on.
Right now. Okay.
Okay, Mr. Chairman, we do still have a quorum. With us, we'll move to the next item of business. Next case on the board's agenda is case 72, Mr. Randy Howington.
Mr. Hargis,
Yes.
I am going to have to recuse from this
okay.
case, so.
Yes.
But
We've got our quorum.
we have a
back with the
quorum now
quorum.
that Ms. Carpenter
All
is
right.
available, so
So the record will reflect that
Mr. Bradford is recusing.
Mr. Bradford is recused. And Ms. Bradford, I think for ease, if I get you to depart to the room back
Okay.
behind here, I'll
Sure.
come get you after
Okay.
this case ends. We didn't do that last time because I didn't have that room available, but now it is available. Okay. Okay, we've got 4 members present, so we are back under case 2024-72. Again, Mr. Randy Howington, appellant, Howington Construction, owner of the property, 9022 Highway 70, requesting the special exception in the AR2A district. Members, if you'll recall, we did have a public hearing in this case. The board deferred the case from June 20th for traffic study. I did receive word from NDOT that they have not completed their review of the traffic study. So I'll leave that to the board.
And we have had the traffic study. I know we've had it for a few days. So, I mean, I'm comfortable with NDOT not being here, especially since it's been heard once before, but I'll leave that open for discussion. If anybody differs, then let's discuss it.
I'm also comfortable, we've had it, so it was in our packet, so.
Okay. Everybody else okay with hearing it, or does anybody feel strongly that NDOT needs to be here?
Well, I would like to hear from them, but
I had a little question about the site distance for the NDOT, because it says over, but I just wanted to see how much over and, vegetation and so forth. So that will make me feel a bit comfortable, but other than traffic study, I do have a new question regarding this case.
Okay, well, I mean, it's just been deferred, so you'll be able to, as I understand it, we did not conclude the public hearing, did we? We just deferred it. So,
That's a good question. Do you know, was the public hearing closed on this?
I think so.
Okay.
the
Yeah, so
public hearing is
was
closed?
yeah.
Okay, so we're just but we can open it back up to ask questions about the traffic study. So, I mean, are you okay, Ms. Johnson, with going and having, if you can ask questions today, are you okay with having it heard today without NDOT being here?
I'm okay.
Okay.
Yeah, because my question is totally different from traffic question. So may I
Well,
phrase?
sure, let's make sure, so we'll go ahead and hear it today. It sounds like there's 3 people that want to, and I don't know, I know that at least the applicant is here, and there may be other people in the audience that are here for the second time. So what I'd propose is, and I watched it on video, but I didn't get to ask questions either. I just propose we give each side 5 minutes. Does that work for everybody? Okay. So I'll make a motion, we give each side 5 minutes, seconds. You second it? Okay. All, any opposed? Okay. So we'll hear from the applicant and,
Good afternoon, board members. Thanks for taking our case up
And
again
technically,
today.
I think you can, I mean, if we're following our normal rules, if you want to reserve some for rebuttal
Sure.
over the 5 minutes, you can do that. So,
Great. Thank
okay.
you, Chairman. Emily Lamb, Thompson Burton, 1801 West End Avenue. We submitted some information that was at the request of the board. Mr. Ransom had asked for some information. He's not here, but we submitted the site plan, which a couple of you wanted to hear, wanted to see, as well as some specifics to the noise and traffic. I'm sorry, the noise and light, which Mr. Ransom referenced. I think our traffic study is pretty clear. It says that the maximum impact, if we are maximum occupied, the impact is going to be a 3% increase in traffic. I think that is nominal at best. The average speed on this road is 50, which is the speed limit. So the average vehicle is traveling at the speed limit. The 85th percentile is 54. So even, if you're going, the highest they got up to 85% was only 4 miles per hour over the speed limit. So I think we have pretty clearly met the burden of showing that we do not have an adverse impact on traffic that rises to the level of denying this application. The noise, as our mechanical engineer reports, shows that we are going to be no louder than 2 residential units, which are also permitted by right. So again, I think that any light regulations, any noise regulations, we're going to comply with the zoning code, and we've got an expert opinion there showing that we're going to require a 37-ton unit, not the 60 or so that one of the neighbors had suggested we would have to have. I would also like to point out that across the street from us is a train track, which also makes a significant amount of noise. So certainly we're going to be contributing less noise than trains that go through the neighborhood. The site plan, there was some confusion over the site plan because we had submitted a supplemental site plan that was not provided to the board previously. It has been provided to you that shows that we meet all bulk regulations. Everything we meet is a by right bulk regulation except the front setback, which is 100 feet, which Ms. Carpenet had pointed out seemed a little bit farther back than the context. But again, that's a special exception requirement. So we've got the more specific requirement I think prevails over the general one, and we've got a specific requirement that we have 100-foot street setback, which we have. So again, we meet all general, all specific, special exception requirements, all bulk regs, any other code requirements, as the various departments have said, NDOT, planning, we're going to meet all of those requirements. This site plan is for the use. Site plans that come before the board are never the full and final site plan because that would require people to go through the process with various departments, which is a waste of time and resources if the use is not going to be improved in the first place. So anything that we are required to do by the other departments, urban forester, landscaping, we meet the landscaping requirements of the special exception, but we are absolutely willing to work with him. I think we've gone above and beyond to show that this is well within the special exception conditions. And so we're happy to answer any questions. We'll reserve my time for rebuttal, but refer you to our traffic study and our briefs.
I think Ms. Johnson did you have a question about the site distance findings in the,
Yes,
in the report?
it says just meet the requirement. According to the Kimmery Horn traffic study, the required site distance is 610 feet, and just advanced site distance is more than 610 feet, but it could be 611, 612. So just curious how much more it's like adequately, safely meet, just barely meet. So just a technical question on the traffic site distance.
Sure, and I was not involved in the traffic study, so I can't answer that. I do know that it's at least the requirement, if not, and obviously more, whether it's 611 or whether it's 711, it's still more. It will require some vegetation removal, which again, we're perfectly willing to do. That's all the vegetation at the front of our property. We're willing to do that, and we'll, again, work with NDOT to the extent we need to determine that.
So if I was looking at the vegetation removal correctly, seems like that not belong to your side of the property. Sounded like the other side of the property vegetation was in a site distance. So how do you plan to handle those vegetation removal on other people's property?
I'm not aware of any vegetation removal on other people's property. Mr. Howington owns several parcels that are adjacent to each other. So all of the vegetation removal will be on his own property.
It's because it's a 26 acre parcel. is
That's
it not, or
correct.
something? Okay, it's pretty big.
Well, I mean, it's 26 acres. Yes, it is. There are 4 or 5 that are all consolidate to make 26.
Right, okay. Any further questions? Okay, you have 2 minutes left on rebuttal if you would like it. So we'll hear from the opposition.
Mr. Chairman,
Hello, Mr. Henry,
members
how
of
are
the
you?
board. Sir,
How are you? Good to see you.
good, good. Yeah,
I
very good.
watched you and Miss Lamb on video a lot the other day, so.
I agree, we've been down here too much. I represent Mitchell and Mary Givens. They reside across the street from this property to the east. Their address is 4002 Beverly Hills Drive, but they have frontage on Highway 70, so they are an adjacent property owner. And I did a preparation here, if you would, of just a few documents. Let me give Ms. Lamb one. Oh, I'm sorry.
Are these things you're adding to the record?
Yes, sir. We would
Okay.
like to submit this for the record and understand you have the right under your rules to reject it, but it's in response to the new submission that was just filed by Ms. Lamb on behalf of her client. And so let me just start with page 2, frankly, and that's talking about the traffic impact study. The traffic impact study is incomplete. You've heard that NDOT's not had a chance to review it. There's really 3 factors I want to point out with the traffic impact study as to why it's incomplete. And by the way, Mrs. Miranda Montgomery, she's a leader in the neighborhood. The Givens, my client, are very elderly and they couldn't be here. So the traffic data was collected on July 2. That's the middle of the July 4 holiday week, not during a period of time, of course, when school is in session. Number 2, there was a citation in the study to Florida Department of Transportation data. I've never seen that before. I don't know what Florida has to do with this in any respect. And thirdly, regarding vegetation removal, the vegetation that needs to be removed is across the street because of the curve. And that property, if you'll take a look at Exhibit A.
And who says that? Is that are you relying on the Kimberly Horn report?
Yes. Yeah. So Kimberly Horn says that it will require some removal of vegetation,
Can
but
you tell me a page note? You have a site on that.
Exhibit A, oh, you mean on the Kimberly Horn?
On the Kimberly Horn report, yeah. Is it Exhibit A?
Kimberly Horn's report.
You're saying the traffic engineers who did the report for the applicant want some vegetation removed that's not on the applicant's property?
We don't know. We don't know, and that's the point. Where's the vegetation? Whose property is it on? If the vegetation has to be removed as recommended, and I'll read it on page 2 of the Kimberly Horn report, it should be noted that vegetation removal will be necessary upon the completion of the development to ensure adequate site distance is met. That's the applicant's engineer. The point is, we don't know, no one knows where that vegetation is because there's no survey depicting where the vegetation is. Is it within the public right-of-way or is it on the property across the street? And if you'll take a look at Exhibit A is a Metro parcel map that I prepared and one of the things that it shows regarding that curve is that property is public park. You just heard Ms. Lamb refer to that property as a railroad being across the street relative to noise. I understand that. But Metro identifies that property between the railroad and Highway 70 as a public park. And so someone would have to approve that in terms of vegetation removal if it's in that public park. And does the city want to remove vegetation from a public park? So I'm just raising those issues because we believe and submit that the study is incomplete. Quickly regarding the noise issue, and it's number 4 on my letter, number 2, all we're pointing out there is the mechanical engineer that did that study is biased. We've included in Exhibit B public comments that engineer's made. And the final page in what I just gave you is a threat that if you don't approve this, they're going to put 217 mobile homes on this agriculturally zoned property. That's from the mechanical engineer. So we think he's biased, and his credibility is certainly diminished by those things that we've attached as Exhibit B.
Well, but isn't that something that's legitimate to point out to the neighbors? We've heard that many times, and I think it's something that neighbors ought to consider. I mean, I don't view it as an improper threat. If it can be developed in another way, I think that we hear that a lot.
I understand, and I'm only talking about the mechanical engineer being biased, not talking about the development alternatives, okay? Quickly, Exhibit A. Exhibit A is a comparison of the setbacks of as-built homes east of the property relative to the 100-foot setback that the swing zone batting facility will be, its proximity to Highway 70. And interestingly enough, this map also depicts steep slopes. The proposed building is smack dab in the middle of a steep slope recognized by Metro, which is in front of that detention pond. Now, maybe it's man-made, we don't know, doesn't matter. The steep slope depiction is on there in that color. The proposal is to put it in that general location. That detention pond drains through that part of the property. I raise these issues because, as I point out on the first page, under the general requirements, operational physical characteristics of a special exception shall not adversely impact abutting properties, including those located across the street frontage, which would be my client. In addition, site design, architectural features, and what we're pointing out are issues with landscaping, drainage, the building style and its height, and in this case, with Exhibit A, the setbacks. So you can look at the character of this residential corridor on the north side of 70 and see how deep these front yards are on these properties. They average 525 feet just with those 5 properties alone. We haven't gone any farther east. So compare that average front setback of 525 feet to what's proposed here at 100 feet. My client, the Givens, will clearly be able to see the back of this building. They can see the back, they can see the side, and everyone driving down the street can see the side and the front. So this is a situation where this batting facility is being placed on this property too close to the street relative to the compatibility of the properties around it. And that's a critical component of the criteria that they must meet. And I'll summarize that in looking at the May 1st site plan. That site plan simply does not include all of the things that they're required to include. The building style and height of the building certainly doesn't match what these residential homes look like. You know, the criteria talks about roof slopes, building orientation, I just mentioned, overhangs and porches and ornamental features. They've submitted a cartoon-like architectural rendering of what they propose to build, but it doesn't talk about overhangs. I think there's a porch on there, but it's not residential in character. What this criteria seems to point out to me, at least, when the Metro Council adopted this language, they wanted you to look at special exceptions in residential districts and make these things fit in a residential environment. This building doesn't do that. So we ask for you to deny it. Thank you.
Question for you.
Yes, sir.
If your issues about the removal of the vegetation and NDOT not having had a chance to evaluate this, they did not apparently get this until today. Would it cure your concerns if a condition was that the special exception was granted, but the applicant had to comply with all conditions put on it by NDOT, including if NDOT believed any vegetation needed to be removed?
Yes, sir, it would, much like the case before you here, before this case. It's important, I think the condition be that an accurate survey depict where the vegetation is located. Then they will know whether they've got to get NDOT approval or the Metro Parks Department, Metro government approval because it's a park.
Okay, appreciate that. Thank you.
Thank you.
All right.
Just to kind of hit the highlights, the traffic counts were taken during the July 4th holiday because we had a very limited amount of time to get the traffic study done. The initial application didn't require it. We did it at the request of the board. We're happy to have Kimberly Horn, if you need any clarification from them on the vegetation or anything, we're happy to get that clarification from you, but I don't think we should be faulted. If we had applied for this just naturally in the middle of the summer, nothing in the special exception requirement says, make sure your application is timed so that you're looking at it at a certain time of year. We just dealt with the calendar that we were handed. Tennessee, as Kimberly Horn stated in their study, Tennessee doesn't provide the data that they reference from Florida, so they use that just as a reference point. If Tennessee had it, they just use it again to show you the level of service that that could be persuasive, perhaps. Again, happy to have Kimberly Horn clarify anything you need to in the study. As far as the engineer's bias, no hard data has been provided by the other side to oppose that. And if you look at the report, attached to his report is the actual specs from the type of unit that we are going to use. And those specs, which are from that company, those are not biased by any means. Those show the 79 decibel limit or decibel level for a 10-ton unit. Again, site plan, we're going to meet any requirements that any department puts on us. Bulk regs, we already do meet the bulk regs, but anything, we haven't gotten to that phase because we're here for the use. We will absolutely meet any NDOT requirements, any requirements of the any various departments in this board if you would see fit to put them on that condition.
Okay, any questions, board members? Okay, thank you very much. We'll close the public hearing and discuss.
If I may, Chairman, please allow me to address this question to our legal counsel. I'm aware there is pending legislation at the Metro Council, and I think it will go into planning, Commission Planning Department for the deliberation, but the first reading was passed at June 28th meeting, Ordinance BL 2024-467, and it defines the boating facility as commercial amusement inside or commercial amusement outside. So that is passed first reading on June 28th. And I don't know if it's going to advance second or third, but if for whatever the reason it passed, so both either this boating facility is categorized, I think because it's an inside boating facility, so that will be categorized as commercial amusement inside instead of currently we categorized as a recreation center. So because we are considering this application based on this application is, yes, indeed, a recreation center. So therefore, it will be allowed in this zoning. But new pending legislation says, yes, now boating facility is commercial amusement inside this case. So if that's the case, commercial amusement inside or outside, neither those facilities are not allowed in residential zone. Only allowed is MUL, MUZ, MUI, CLCS, those commercial type of zoning. So by the time we approve and by the time if this were legislation, pending legislation were to pass, we are approving non-conforming use by the time this facility will be built. So I have a little, what is our authority or, I have a little uneasiness to knowingly approving future non-conforming use or facility. So if you want to talk to that, I appreciate it.
Yes, thank you. That's a good question. So last year, the General Assembly passed, has become TCA 2943-101, which is the rejection of the pending ordinance doctrine. So prior to that point, there had been case law that would have, depending on the timing of when the ordinance was introduced, would potentially have effectively frozen building permits that have been applied for pending the outcome of that ordinance. However, that's no longer the case, and under the statute, the merits of a permit application are judged on the basis of law in effect at the time of application.
Is that the Tennessee Vested Rights Act? That's the same.
I forget what it's officially called. It was just passed last year.
Okay,
It's a little different than the Vested Rights Act.
Yeah.
but the same effect essentially.
Functionally, yeah.
Yeah.
We're to look at applications when they're filed with us.
It just explicitly repudiates the pending ordinance doctrine that was in the Harding Academy case.
Okay. Well, again, I mean, I know it's a rural area. A lot of the neighbors, it seems to me, that a big concern is the traffic and preserving the nature, the rural nature. But that's, as we've all, I think, these special exceptions, that's not our job, is to decide what we want to go where. So in my opinion, the conditions have been met. I'm satisfied that the site plan is specific enough. It's as specific as site plans we've approved special exceptions with before. We've got a survey with the dimensions of the buildings. We've got, I guess we don't have the construction drawings, but I'm satisfied it's adequate enough. I do think a condition ought to be that there be compliance with all standards that are all requirements of NDOT, which would take care, I think, of the applicant's concerns about the vegetation and the other things. But again, it's a special exception, and our discretion is very limited, which in my experience makes it, well, we just have a lot less discretion, and I think the requirements have been met. So that's where I am on it.
Mr. Pepper, I agree with you. I think when we look at special exceptions, we look at the general standard and the specific standard. Those are the two standards that we'll consider. And I think under those two standards, I didn't see anything, or I didn't find anything that would violate either of those standards. And I was going to add that condition. I think if the applicant follows all NDOT conditions, given where this is, I think I understand the neighbor's concern, and I think Mr. Henry did a really good job of outlining that, but I'm inclined to approve it.
I would still feel more comfortable hearing from NDOT, because that's their expertise, and so I'm probably.
Well, it's going to take
not-
4 votes, so if you're,
Yeah.
I think we might just go right into making a motion for a deferral
Deferral.
if that works, because, we're going to have 4 votes, and we're going to be doing it again anyway. Okay.
Okay, second?
Okay, all in favor of that motion? Okay, so it's deferred, is it deferred to I'm assuming the next meeting would be.
Yeah, by default, it'll be the next meeting. Yes, so the next meeting will be August the 1st. Here in this room, I believe so. Okay, we've confirmed with General Services.
Can you tell me that date again?
August 1st.
August 1st.
Yes, sir. This is the notice for that meeting. This case is deferred till August 1st. I will reach out to NDOT as staff, find out where they are. I'll communicate with both counsel for both parties to let them know whether we're on or not on. I understand, want to make sure the board, if NDOT tells me, hey, we can't be August 1st, it'll have to be the 15th,
Okay.
we'll notice that to the parties' counsel and on our website and that sort of stuff. So.
Thank
And
you.
Ms. Lamb, Mr. Henry, thank you for your very thorough materials. It
Thank
always
you.
makes it a lot easier to get through this stuff, so thank you.
All right, members, we're going to retrieve Mr. Bradford, and while we're doing so, I'll go ahead and read this next case under Old Business, Case 83. This is a case that we heard the case originally. It was deferred. Public hearing occurred. It was deferred to June 6th. At the June 6th hearing, the members that participated in the first case, I didn't have a quorum, so I had to kick it. June 20th. I had to move it to today's. So looking back at the order of the parties that participated, all 5 of you present are able to participate. The 2 members who were not here. So that's the side of that. So in this case, this was and I'm happy to go back over the slides to refresh your memory. This was a special exception case for a daycare home for adults, listed as a large daycare type at the corner of Windermere Circle and McGavick Pike. And I'll just show you the photographs from the hearing to maybe refresh your memories. We did have a full public hearing. But that's where we stand on this one. We would need a motion, one way or the other, in this particular case. And the reason I recall now that we couldn't proceed, we had not received a recommendation from the planning department, and that's why we couldn't proceed at the original hearing. We do have that recommendation. It is recommended approval, I believe, is it not, Christie? So then we postponed it to the 20th, and then I didn't have a quorum, so now we postpone it till today. So,
Yeah, I make a motion that we approve the special exception based upon demonstration of the factors required for a home adult daycare facility. The applicant has demonstrated that compliance, and planning's recommendation is well taken.
I'll second that. So there's a motion, a second. Any discussion? All in favor?
I just had one
Yeah.
condition. So I completely agree with Mr. Bradford in the motion. One thing that I wanted to add, because of where this is, and there were concerns about parking and, parking on the street because of how narrow the road is, and I know where it leads, like, if we could, and it maybe, my brain doesn't work as well as it used to. But, just making sure that the conditions are that we approve it, but they keep all the parking, transport, everything into the driveway, and it doesn't happen on the street, and that everything happens within I think they have 2 driveways there, it circles around, and so that everything is contained to that, just to not impact the flow of traffic within the neighborhood. And I think your condition covered that. I just wanted to make sure.
Yeah, I think
And if it did, ignore me.
No, well, I mean, I think it's a good point. I don't know that we can condition not using street parking, because I think street parking is just allowed by law in this neighborhood, so
It wasn't the street parking, it was just
The
because we've done this before, it's a drop-off.
Ingress, egress.
Yes, all the drop-offs have to occur, because we've done this on other daycares,
Yeah,
as long
yeah.
as I remember.
I have no issue with that, with a requirement that drop-offs occur, on the driveway and, outside of the right-of-way, within the bounds of the property line.
Okay, so your motion is amended accordingly?
Yes.
Okay, and I'll second the amended motion. Okay, so we'll take a vote unless there's further discussion. All in favor? Any opposed? Okay, that passes.
Okay, Mr. Chairman, the case 83 has been approved on a vote of 5.
Before we call the next case, does anybody need to take a break, members? Okay, so we'll go to the next case.
Okay, next case, under old business is case 85. Give me 1 second to get that. Pulled up for you. Oh, okay. I appear to be, there we go, okay. This case 2024-85, is 3721 Hobbs Road. This is at the intersection, you see, of Hobbs. And the request here is you have to forgive me, I don't have the screen for presentation screen. There we go. Deals with a fence that has been erected on the property in this general vicinity here. And then the next photograph shows the fence portions that would be not in compliance. This would be along Hobbs Road. Along the intersection, the fence has been brought into compliance there. Just recapping, the fences consist of 2 parts. One is an open fence. This view is along Hobbs Road. This open fence is allowed up to 6 feet in height on the property line. However, when you transition over to a solid fence, as you'll see that occurs here, the setback changes, and there's a 10-foot setback required for a solid fence not to exceed 6 feet in height. These particular panels are 6 feet. Once we get into the back, if you'll notice where it becomes the backyard, it goes to 8 feet. So the variance that's listed is a variance from 6 feet to allow 8 feet for the first 10 feet of this site. So once they clear the 10-foot mark, then they can go up to 8 feet. If you notice at the prior hearing, the council member was supportive I believe that the jog or the change that occurred here dealt with some utilities that exist and to accommodate those so as not to block utility access. I think this one photograph here shows there's an easement there for forgot what the anchor tie down from the NES pole. So it was jogged there. So kind of recapping, the variance portions only cover the portions of the fence within 10 feet of the road, and then a slight portion of this rear property line where it exceeds 6 feet. Again, all other respects, the fence does comply with the code.
Can you go back to that picture?
Yes,
Of the,
site plan.
and using that red marker, can you show us the parts that are, that where you have it now, there's adequate setback for 6 feet, is that correct?
From this point on, it's slightly at 10 foot. It has to be 10 feet back. I don't think it's quite 10 feet. At this point, it jogs closer to the road. That portion is definitely not in compliance.
Okay,
But I think that entire stretch of road is just inside of 10 feet.
But that part where it jogs was due to the utility line
Yes.
placement. Yeah, okay.
So again, looking at
and then the issue in the
There's
back
that
is it's
jog
8
you
feet instead of 6 feet.
correct. And it's just a 10-foot portion of that's along that tree line.
Just a 10-foot portion in the back.
Yes, sir.
Okay.
The rest of it above at 8 feet from that 10-foot mark back is fine. It complies with the code. So in this photograph, if I'm looking in his backyard, at the point we hit the 10-foot mark from there inward to the back corner, that is in compliance.
Okay.
So it's just this joggy portion here, or any portion of that fence that's within 10 feet. And again, we did have council member appeared at the last hearing in support for the request. Are there any parties present in opposition to case 85? Okay. Mr. Michael, seeing none, you'll have 5 minutes.
Thank you, Mr. Hargis, and thank you, board members, for hearing our case. My name's John Michael. I'm from the Thompson Burton Law Firm here in Nashville. I represent the appellant, Mr. Grindstaff, for his residence here on Hobbs Road. My law partner, Josh Lee, and I have been working on this, trying to do the best job possible explaining how we got here. Short version, as you probably know, there's no permit required for the construction of a privacy fence like this one. However, there are very specific guidelines about the height, the setback, even materials, open versus closed, etc., that anyone who wants one of those fences has to comply with. So wisely, Mr. Grindstaff reached out to Metro Code, studied the website, put in some inquiries, and just honestly, whatever the miscommunication was, got it wrong. That's the bottom line. He worked with his contractor, who then went and did the same thing. Let's make sure. Let's study the website. Let's call down to Codes Department. Go check the website. Okay, we did. We think we're good. We think we're good. We were not, in fact, good. And so mistakes were made in the construction. And I think, thank you, Joey, for the really clear description. Would you be willing to put that small site plan back up? I'm going to refer to that short right-hand line as the eastern property line. That's the one where you see where the approximate placement of the house is. If you drew a straight line from the corner of the house over to that eastern property line, from that point up, the fence needs to be shorter than it is. We are asking for that variance. There is no advantage gained here. This is not a get away with one. This is they tried to get it right and they got it wrong. The hardship associated with that particular portion of the variance request is the fact that we have a corner lot. The actual front door and facing of the house goes to the west, not to the Hobbs property. So in reality,
It does not face Hobbs Road.
there's a garage there, but the front door is
The
not
front
oriented to
does not
Hobbs.
face Hobbs Road.
Oh, thanks, Mr. Hargis. That does show it well.
So
So
that's
you got the-
Hobbs Road we're looking at from this side.
Standing
right
on the
here.
Hobbs Road sidewalk,
Okay.
basically, yes, sir. Compliments to the former council members. It is a beautiful gleaming sidewalk and serves the community well. However, the zigzaggy fence that we showed you along Hobbs, now, Joey didn't go to the inside of the property because he's not supposed to, and thank you for that, I suppose. But the zigzaggy fence works around multiple guy wires from NES poles, multiple, granted, newer plantings on the outside of the privacy fence, but mature trees on the inside of the fence. And although I don't confess to know exactly what it was, the markings on the equipment were plain. Above ground hardware built into the ground that is irrigation equipment just inside one of these zigs or perhaps zags in that fence. Mr. Pepper, I think your question to Mr. Hargis was, slightly closer to the driveway. We think that portion was just a shade closer than 10 feet, 9 to 9.5 perhaps. But clearly, when you get farther to the northeast corner of the lot, that portion is closer to like a 6-foot push off of the sidewalk. So it's definitely too close.
Why was that done? I see there's a utility pole there, but why did it zig and zag like that?
Again, mature growth trees, as you get closer to the corner, we're working around those. If you did the perfectly straight line at exactly 10 feet, which is what the law calls for, or no closer than 10 feet, you would be right into trees, root beds of other mature trees, the previously mentioned irrigation equipment. And so this was an effort to work around the obstacles that existed there before the fence was built.
Was it also done to save mature trees?
It definitely preserved mature trees.
Okay. I'm asking for Mr. Lawless, who he would want to know
Yes.
that. You know, we all know that, so.
So again, by way of short recap, it's my understanding there's no opposition present. The council member, Sandy Ewing, was kind enough to come see you last time and give her statement of support for this appeal. It's our understanding nobody's had true problem with it. In fact, as to the first portion we discussed, the eastern property fence, even the neighboring property owner to that eastern property had no problem with the fact that it was, 2 feet too high for however many linear feet going south down the property line. Finally, I'm very pleased that I'm representing a client who, both himself and through his contractor, made earnest efforts to connect with Metro, talk with Metro, comply as best they could. Mistakes were made. They just got it wrong. So for those reasons, based upon the corner lot having an unusual effect of the borders of the house, creating the shorter fence restrictions to that eastern property line, and because of the hardships associated with the mature growth trees and the pre-existing hardware for irrigation equipment, we respectfully ask that you grant the variance for the fence as it exists.
Any questions for Mr. Michael? Okay, and is there any opposition here? Let me confirm. I think that there's not, and so there's no opposition, so we'll close the public hearing and discuss.
Yeah, I think the shape, the trees, the power lines are all three things to me that, and just to editorialize for 2 seconds, and I know our zoning administrator has supported the idea of a permitting scheme for fences, but it's exactly the reason why a permitting scheme for fences would be good, so that people like the appellant who acted in the utmost good faith in trying to do this the right way could submit a plan that would look at it from a tree standpoint, from a power line utility standpoint, and not, understand that a fence should be constructed in a way that takes into consideration a lot of other things other than just, the line from point A to point B. So I will take the opportunity to say thank you to the appellant for the work, and that I'm very supportive of this request. Why not? I will make a motion to approve the variance as requested, based upon several features regarding the nature and shape of the lot, including its seemingly circle and parallelogram shape, coupled with the presence of utility structures and mature trees on the site, and ask that we approve the variance for this fence as requested.
Okay, there's a motion and a second. Any further discussion? All right, we'll vote. All in favor? Any opposed? Okay, that passes 5-0. So we probably need to take a 5-minute break now. We've been going about an hour and a half, so.
Board will be in recess, and we'll be back shortly. All right, the next case, and the first case in today's new business is actually an older case. So ironically, it is a new case before us. Mr. Amos Howard Sr. is the appellant, 601 11th South Trust, the owner of the property at 601 South 11th Street, requesting an item D, which is in addition to a non-conforming structure in the RS5 district. The appellant is seeking to construct a triplex. Let me rephrase that a little bit. The applicant's actually seeking to put an addition on an existing triplex. I've looked over the drawings that have been submitted. He is retaining 50% or more of the existing structure, but is proposing to put a second story on the existing and expand, and I'll show you the site plans here. But before I do, are there any parties present in opposition to case 40? Okay, seeing none, there'll be 5 minutes on this, but let me just go back over the slides. This case did come before the board previously. We did have an original public hearing. Member Ransom had some questions about the unit in the back of the house. The applicant took those to heart, went back and reworked this plan and is bringing essentially a new plan to you. So we made him renotice and re-advertise. But we did keep the same case number for continuity. But this is the existing.
Can you remind us, so this is an item D, so the standard is?
Whether the board feels that the proposed addition is appropriate under the code.
Whether what?
The addition is appropriate.
Okay, it doesn't have anything to do with expanding the non-conforming square footage?
It does not. It will conform with all other regulations, and the reason this is before you, this is a triplex, and this is a non-conforming use, so it's an addition to a non-conforming use. I did say structure, but the structure itself's fine, meets the code. The new structure would meet the code as well, but it's an expansion of a non-conforming use. In 1740-180, D in your power said the board shall determine the appropriateness of proposed changes to non-conforming uses or structures. And so that's the site under the Metro Code law that gives you jurisdiction. And this was and I'm going to show you both the original plan and the proposed new addition. This is the original plan. The applicant had someone else presenting the case last time, but they are going to present their case themselves. So this is the prior plan, and then the revised site plan, as you'll notice, the addition will go vertical and to the side, and they've decreased the amount of construction to the rear of the building. They're going to bring the parking in from the rear, whereas the prior plan created a driveway down the side. Again, view of the subject properties on that side of the street. I did not get any photographs of across the street, but across the street we've got some new construction. I'll pull up an aerial to show you that. This was the original plan. That was back before the board with that addition to the back. So this is sort of a profile of that addition. The street in this drawing, this is the prior drawing. The street's out here. So all the addition was back and up, and then the new construction, same elevation, a shallower construction, but they're going to go vertical with a second story here. So this is the front elevation of the proposed structure in front of you, and then the view of the rear and the side. And with that, I'll turn over to the appellants. Members, I'll pull up an aerial while he's talking, so I give you a perspective of what's across the street. But with that, the applicants will come forward. I believe Mr. Howard's here, and a member of the neighborhood's also. We spoke at the break in support of his request. So with that, I'll turn it over to you, sir.
I'm Amos Howard on the property here at 601 South 11th.
And can you give us your address, please, sir, for the record?
Which address?
Your residential address.
Oh, my residential address is 3946 Lakebrook Drive in Murfreesboro, Tennessee.
Okay, thank you, sir.
All right. So I'm proposing that we are allowed to keep the same number of units there to again bring the to rework it as it relates to just bring, as already said, instead of doing it like we were proposing before, to go across vertical and continue to keep the same elevation. We've met all of the burden of proof, I guess I should say, based on the code for the non-conforming. So we brought the parking in at the rear. versus having the driveway that we had before. So some of the concerns, I think, that came up, or questions, we tried to address all of those concerns, as well as make sure that we were in compliance with all of the elevation and regulations as it relates to the non-conforming.
Okay, any questions from the applicant?
The current plan in our packet shows unit A and B and C and first floor and second floor. Is this the current plan? It shows option 1, option 2, option 3.
Yes, ma'am.
That's the newest current plan you are currently proposing.
Yes, ma'am.
So my question is, the second floor, let's start with the first floor. If I take a look at the first floor plan, the unit C, you are coming from you passed unit A and B, and then coming to unit C. And from the front porch, you come in, come to the foyer. And then on your left, there's a deadbolt. And then going up the staircase, and then come to the second floor. And then if you come to the second floor, staircase turn, and then you run into deadbolt. And then both second floor and first floor has 2 bedrooms and 2 kitchens, 1 kitchen on each unit, and living room and, great room and so forth. So it looks like the first floor and second floor independently has 2 bedroom units. Almost look like you're proposing quadruplex instead of triplex. So what is the reason you have such kitchen in both first floor and second floor?
Right, you should be, the plan should only have the kitchen on the first floor. You have I don't know which one, are you looking at the?
Yeah, Ms.
I am
Johnson, I
looking
can
at
help with
A1,
that.
A2 in our packet, page
Oh, that's probably.
6.
Yeah, Ms. Johnson, I can help with that. Given the nonconformity as being multifamily, there are some state law issues that kick in. We will make certain there are not more than 3 kitchens in that facility. There can't be more than 3 dwelling units. That would also include any type of in-law suites as well. You're limited to just 3 dwelling units. And when we do the permitting, we're going to look at his floor plan and make certain there are not more than 3 cooking facilities, 3 types of dwelling units.
Right, I think that's exactly what Mr. Ransom asked at the last meeting. And that's why I asked this proposal is the current proposal, because he was adamant about not having look like extra unit. Because first floor, each unit has kitchen and, bathroom, and then 2 bedrooms each. And then when you comes to second floor, it has, specifically it says deadbolt. So it seems to me it suggests you going to the first floor foyer, and then you will see enclosed staircase, almost as if you are going into, 1 unit in the first floor, and then coming up to the locked deadbolt, second floor. It suggests to me it's like a different unit. So it really, I understand our zoning administrators saying, yes, we are not gonna, approve this construction, but if we do approve this, plan as submitted, they could mistakenly make as it submitted with 4 kitchens and, like 8 bedrooms and total.
I'm not sure what plan you have, but the one I have, if I may give you this plan, because it doesn't have a kitchen on the second floor.
I think it got confusing because the existing plans the old plans were also included. Yeah.
Oh, yeah,
The new plans are there.
Yeah. They're after the old plans.
Yes.
Mhm.
Okay, that's why I was asking.
Because the A2 I'm looking at, you referred to A2, Ms. Johnson. Now, the A2 I'm looking at, I don't think has a kitchen.
Yeah, I was looking over Ms. Johnson's table. The plan she was looking at was the prior plan.
Okay. So the A2 of the new plan does not have, the second floor does not have a kitchen. And it's dated July 17, 2024, so it would presumably be the most recent.
Got it. So one more question. I think I don't know, it's applicant or probably Joey. The proposal, so I understand it says triplex, so current use is triplex, but the submitted plan suggests Unit A and Unit B. I don't understand where the Unit C in this current plan. So is there any proof or anything to back up? Yes, indeed, it is a triplex because the floor plan submitted Unit A and Unit B. And the picture I see, it looks like a one-story, house. So I really cannot tell. It is indeed recorded as a triplex, but seems like a usage has been duplex. I just want to make you sure.
Yes, ma'am, it is. We verified both by NES records and our own permitting, prior permit, back when the house was originally constructed. It is a legal three-family dwelling. Two in the front, there's one kind of sits in the back portion of the existing structure. And then his revised plans showed that I copied you would have the 3 units on them as well.
If you look at the PDF, it's page 9 of the PDF packet that was submitted shows Unit A and Unit B in the front, and then Unit C sitting behind Unit B.
Yeah, and now the new will be.
They're not Unit C is not shaded the way that A and B are, but it's listed on there. So that's what I was looking at.
Correct.
Thank you for the clarification. I just
Yes,
want to
ma'am.
make you sure.
No, that's
because
good.
we are
No, it's good.
following,
Good
the
clarification too, because there are some non-conforming situations that come for multifamily in a single-family zone. They're protected differently under state law, and they're only protected for involuntary damage. So sometimes we have folks that want to take a triplex, bulldoze it, build 3 brand-new structures, and they're just not allowed to do so under the current zoning. So yes, ma'am, thank you for that question.
Well, thank you for submitting the new plan. So with this, less confusion, I'm fine with it. Yeah, because the 4th kitchen was definitely not good as submitted.
Yeah, I remember when this one first came in and Mr. Ransom's comments on it. And I'm satisfied with this new plan, and I think it's good.
Is that a motion?
Oh, why not? I'm on a roll, I guess. I'll make a motion that we approve the application based upon the current pending plan.
Okay, I'll second it. There's a motion and a second. Any further discussion? All in favor? Any opposed? Okay, that passes. Thank you.
Case is approved on a vote of 5-0. The next case before us is case 2024-76. Mr. Gil Gonzalez, the appellant and owner of the property at 300 Myrtle Street over in East Nashville. He is requesting a variance from the side street setbacks in the RS5 Corridor Design Overlay District, Dadu District, in UZO. The appellant seeking to construct a detached accessory structure with insufficient side street setback. Refer to the board under section 1712-030. Are there any parties present in opposition to the gentleman's request on case 76? All right, Mr. Chairman, seeing none, let me go through the case record first, and I'll turn it over to you guys when I'm done. The subject property is located, as you see here, at the intersection of, and then the variance request will be located, you'll see on the aerial photo, it's on this side street is where the variance request. The site plan submitted by the applicant shows a 10-by-16 shed 4 feet from the right-of-way line, back of the sidewalk over off of Smiley Street. the zoning code requires a 10-foot minimum side street setback. This is looking at the subject property from Myrtle. Smiley's over to the left-hand side. And then the view looking toward the gentleman's backyard, the structure will be located back in this area. And then view up Smiley Street, you'll see some new construction going on across the way. Interesting, that bus that I saw out there is actually on the aerial too. Same place, so I guess that's where they park it. It's good, okay. Looked like a fun bus. But the proposal looks like that building's gonna sit kind of in that grass area, what you see. A little bit. Oh, okay. Oh, back in here, okay. Okay. And I didn't go on the gentleman's property to double check, but that's where it's gonna go. The code requires a 10-foot setback off the back of the sidewalk for the fence itself, is within that. Let's see if I don't have another shot, members. Okay. With that, I'll just leave this here. And again, no opposition, gentlemen, if you'll identify yourselves and addresses and make your case to the board.
Great, thank you. I'm Gilbert Gonzalez, 300 Myrtle Street. I am the owner and I live at 300 Myrtle Street. And this is my spouse.
Andrew Hofer, 300 Myrtle Street. Now, as you can see from the site plan, what we're seeking to do is just put the shed closer to the fence. Reason being that we have extensive landscaping in the backyard, not all of it done by us, some of it existing. If we were to move it 10 feet into the yard, one, we'd have to move boulder walls. Two, there is an existing tree right in the middle of the yard, which is right now obscured by the tree in the alley. But yep, right where that pointer is, there's an existing tree. And putting that shed 10 feet into the middle of the yard would, a 10-foot setback would literally be on top of that existing tree that's in the middle of the yard.
Even if you're 14 feet from the alley?
Yes, sir.
Okay, because it looks to me like that tree's.
Well, the tree that you can see on the aerial is.
You're saying there's another one underneath it.
Yeah, exactly. Yeah, precisely. It's also notable that it's a corner lot. My understanding that the council's general reason for those setback requirements is in order to not impede sunlight or views from neighboring properties. We are in fact putting this shed further away from any adjoining properties than the setback would allow us to. Beyond that, no harm to public welfare, I know is one of the requirements. You can see in this aerial photo is when that construction just started. But the neighborhood that we're in, now the zoning changes at Smiley Street, so that's part of it. We're single family zoning. They're building a triplex on a lot that's half the size of ours. I don't know that putting a shed 4 feet from the fence is out of character with a dense neighborhood, what is rapidly becoming a dense neighborhood. And with that, I'll turn it over to you guys.
Any questions?
Oh, one more point. The shed's unelectrified. It is just storage.
Thank you. There probably would have been a question about an Airbnb potential of the shed.
It's just storage.
That sounds good. I don't want to meet the person who's going to stay in an unelectrified shed as an Airbnb.
That's right. No, we're gardeners and I don't have space for my lawnmower. This is what it comes down to.
Understood. Thank you.
Okay, we'll close the public hearing and discuss. Well, it's not a big ask. It's 6 feet. I did not see a hardship until he pointed out the tree. And I think we've got to find a hardship. It's not a great picture of the tree. But if that would be in the way of the shed, then I think that could be a hardship. So.
Yeah, Mr. Chairman, not all photographs I show you or everything I take. Sometimes I'm like, oh, I took that and that wasn't really relevant. But give me just a minute. Let me pull up.
Yeah, my thinking is they could cut the tree down and build it by right in the backyard, or they could get the variance and keep the tree up and.
And the tree itself is a native sumac.
And assume it was there when you acquired the property, the tree was?
It was.
Okay.
Well, I mean, I can see it now that you pointed out. It almost looks like it's an evergreen of some type, because I see the green underneath the one that's kind of leaning from the alley. So I'll make a motion that we approve based on the fact that it's a 6-foot ask, and it's the hardship being that it would require the removal of a tree that's been there.
Second.
Okay, there's a motion and a second. Any further discussion? Okay, all in favor? Any opposed? Okay, that passes. Thank
Okay,
you.
case is approved 5-0. All right, Mr. Chairman, the next case before the board will be case 2024-90. Mr. Matthew Geis, the appellant, Laura Robinson, the owner of the property located at 1401 Harwood Drive, requesting a variance in the maximum footprint allowed to build a new single-family residence in the R10 district. This is in a contextual overlay, thus the need for a variance, and I'll explain that in a moment. The appellant is seeking to construct a new single-family residence. Are there any parties present in opposition to case 90? Mr. Chairman, seeing none. Gentlemen, can I have a seat there? Oh, sure. Just Christie here will get you. I'll go through the slides for y'all. No, I'm good. Thank you. The subject property is located at the intersection here at Harwood Drive, and the request before us is to, and I'll flip back to this aerial so we can talk about. But this side of the street is in a contextual overlay district. The variance request, he is allowed based upon the average height times 150% of the next two houses north to build, and then subtract out the existing residence. That would allow for 587 square foot footprint, and they are requesting a proposal of 750 square feet in a story and a half.
And the 500 is under the contextual?
Under the contextual overlay district. And the contextual overlay district only covers, in this neighborhood, the parcels north in this. So the contextual overlay starts here, covers, and goes north. If you'll remember there was a case previously, an item A on Harwood, further north. This is the southern portion of that same overlay. But when you look at the two houses to the north, multiply that times 1.5, subtract out the existing structure, that leaves what they're allowed to build, and that's 587. They're proposing 750 in a story and a half. This was actually the first plan I got after the council defined a half story. And our architects that we have on site says this complies with the new story and a half provision. So less than 50% of the dormer space occupying the non-gabled in, and the top floor doesn't exceed 75% of the square footage of the bottom part of the floor. But again, the 750 is just a footprint. That is not a floor area ratio. But this is the existing residence that will remain on the property. And then a view approximate location on the other side of this fence. This particular, on my day of the visit, couldn't find the public hearing sign. What you may not be able to notice is look like somebody backed over it. There's tire tracks here, so whoever just went off the road and flattened it. And then a view of the properties across the street on the south side again, and this is the opposite corner. The front of that residence in that first photograph was just to the left here. But and again, a view of the immediate aerial proposal will be to put that structure in this general vicinity. But that is the nature of the request. There is no opposition present.
Is there opposition present?
No, sir.
There is none, okay.
And with that, I'll turn it over to you guys.
Thanks, Joey. Yeah, so
Hit your microphone. Sure. First button down at the bottom there, on the right-hand side.
And please state your name and address.
There you go.
Hello? All right. My name is Matthew Geis. Thank you guys for having us. This is my building partner, Abram Mitchell. So the short summary on this one is that we can build a second dwelling on the parcel per the current zoning of R10. But the overlay, what it allows us to do is not really have a house that fits very well within the neighborhood. And my understanding of the overlay is that it's in place to protect the neighborhood and make it look, preserve some of the, just preserve the neighborhood. So the overlay allows us the second dwelling to have a footprint of 587, and we're planning to have 750. The average footprint of the two adjacent homes is 1,176. And in the close-by neighborhood average, it's a little bit closer to 1,400. It's a large corner lot, so it wouldn't be a tall and skinny or a front and back with shared driveway type of build. We can build the home with the nearly 600 square foot footprint, but we don't think it would fit very well within the neighborhood. The increase to 750 would allow us for a more appropriately sized home for the lot, and for the end buyer wanting to live in this nice area of East. So, yeah.
Okay, any questions? Okay, we'll close the public hearing and discuss. Thoughts?
If I may, could you please repeat why 583 came from? I don't understand, because this is a duplex lot, and I understand, contextual overlay averages the size and height and, 125%, and then building coverage will be average of up to 150%. So I do not understand why 587, that exact number came from.
And was it 587 or 507?
587.
587.
So the 587 average would take the two houses, like on this slide here, you would add the square footage of these two footprints of these two residences, and multiply that times 1.5, and then subtract out the existing square footage of the existing home that's staying. And that leaves the pool of remaining square footage that they can build to and comply. And that's where the 587 comes out. Once you do the math of taking those two, multiplying times 1.5, and then subtracting the existing square footage on the property, that leaves the remainder of 587.
So with that token, I don't know if Dadu is allowed in that particular section or not. So under the contextual overlay, so Dadu, we allow up to 750 square foot for Dadu case. But with that contextual overlay, Dadu will be shrunk as well?
Dadu's would actually be not shrunk in that the Dadu overlay has its own restrictions as far as size of the thing. So, and Dadu's are, by their nature, supposed to be treated like accessory structures. And so accessory structures, when we have those two overlays kind of working together, the Dadu is treated like a shed or a garage. And so it doesn't count toward the square footage allowed. So you could, in theory, build a 750 square foot structure and be a Dadu. The only restrictions there is that Dadu cannot be sold, and the owner of the Dadu has to live in the front. So it's really more of an ownership. They couldn't HPR it or condo it, but the base zoning allows duplexes by right, subject to the restriction of the other. So it's kind of an interplay between the two different overlays. I do try to encourage the council members, don't mix those two, because you'll end up getting a larger Dadu than maybe the neighbors intended. And depending on the size of some of these lots, it could be as upwards of 1,000 square foot Dadu.
Yeah, that was my kind of question, because it's kind of strange, because Dadu is allowed, up to 750 square foot, but because of the contextual overlay, and particularly in R zoning, make it kind of freaky, strange.
And I think that, one of the things the applicant indicated is, I think if the intent of the overlay was to make the structures consistent with the surrounding neighborhood, in this case, complying with the overlay might actually create a structure that's less consistent with the surrounding structure, with the neighborhood, because it would be something that's taller and with less of a footprint across the property. So
would the hardship be that it's a corner lot and complying with the contextual overlay would?
Yeah, I think that I think it would be the corner lot coupled with application of the contextual overlay would create a unique circumstance, in my estimation.
May I speak, Peyton?
Public hearing's closed.
Yeah, public hearing's closed, we'll, okay, yeah, I follow you on that.
One question, in this contextual overlay, height, as far as I see, it's not, within the contextual overlay height, correct?
Yeah, the contextual overlay height governs in this case. And so in this instance, because the average size of the homes, the average height of the homes, most of those homes are single story. There are a few story and a halves there. They're limited to 27 feet in a story and a half. Because how the average works. If the average had averaged out more than 27-foot average, let's say we were on the other side of the street, a little bit north, see where those 2- and 3-story homes got built prior to the overlay? Those would probably kick the averages on that side of the street to allow people 2 stories. But in this case, they're restricted because their side of the street are all more kind of 1 story. So they're allowed 27 feet in a story and a half, which they comply with. That portion's fine. It was just
And they would have to comply with that no matter what.
yes. We have to run the math to see which, but it does vary, and over time, as bigger homes get built, those averages start going up, and
So my understanding, I think it goes to your question, is the only variance they need is the square footage. They're good on height, everything else, parking spaces, everything else.
I mean, when I looked at this, I didn't see a hardship. I asked myself over and over again, what is the hardship? And it doesn't seem like there's one. This seems like a choice. Seems like a self-imposed choice. I don't think the contextual overlay creates this. The contextual overlay's there. It's been there to keep the design in line. I don't, like, even looking at these pictures, I don't see that much of a difference in these houses other than the porch size. Like, and I see, like, but I mean, even looking at the pictures, they're both about a story and a half, so it doesn't impact height. It's literally just to build a bigger home. And without a hardship connected to the land, it's hard for me to overcome that hump in my mind. So, I mean, I understand Mr. Bradford's argument. I definitely do. So I get your perspective. It's just when I looked at this, I kept saying, what's the hardship?
Yeah, I did too, and it's, I mean, in my estimation, if it's a hardship, it's a thin reed of a hardship and it's a corner lot combined with the effect of the contextual overlay. But your point is the contextual overlay is the contextual overlay, and that's just math.
Yeah, the contextual overlay doesn't impact anything other than the size of the house.
Right.
You can still build a house. It's still a buildable lot.
Yeah.
It's just not the size of house you want. And that's not really for us to decide.
And so your point is the corner lot doesn't really, the fact that it's a corner lot is.
Because that's not why they're asking for the additional square footage. The fact that it's a corner lot has nothing to do with the square footage ask.
If it wasn't a corner lot, would you have to take, so if it was in the middle of the neighborhood, would you have to take the average of 4?
you would do the average of 2 on either side, or 3, depending on where it was in the.
But isn't this, I mean, because it's a corner lot though, they have more land to build on. Like they have more space to build than those people in the middle. The people in the middle are more confined. If you're on the corner, you feasibly have more space to build.
Yeah, I'm also seeing, I mean, I'm seeing houses that are across and then catty corner that are significantly larger than what would be built.
What will be built.
Yeah, in conjunction with. So, I mean, I think this is one of those situations where when an overlay comes in after you've already had some stuff that maybe is not consistent with what the neighborhood's done, you get a pretty weird development pattern, which I think this area seems to have.
Yeah, I'm with you, and I think Ms. Davis's point is though that
Yeah. I
Are we
think.
really just changing the contextual overlay because we don't like the math that
Yeah.
adds up?
Yeah.
And I get that.
if I approve this, I'm undermining the point of the contextual overlay.
Yeah, I think that's right. I mean,
And-
I think that.
Yeah, and I think my concern is I think that it seems like they're trying to build something that if the point of the contextual overlay is, having houses in that 1,000 square foot range, that, we're essentially, we're looking at a house that does, yes, it sits on sort of the backside portion of this corner lot, but it does seemingly fit more with what's around it. So that was I don't know. I think the contextual overlays continue to be the thing that just drive me the kind of craziest around here, because it's the point, the sort of spirit and purpose of them seemingly can vary. Sometimes it's height, sometimes it's size, sometimes it's aesthetic. So I don't know.
Let me pose some question. The calculation of the average lot size. So Joey, you said because of the corner lot, so exactly which house you calculated?
It would be these two north.
So what if we calculated to the other side? The corner,
Here
the other corner,
or here?
yeah. The,
I'm not sure how that math turns out.
like a corner block kind of averages out in that corner, because I think the intent of the contextual overlay is not to build enormously out of the character house, particularly, high and big.
Well, and the other thing, and I think this is a really well taken point, is that this house, can we reopen the public hearing for a quick question to the?
I don't have any objections. Go ahead.
Would the house be oriented towards, which street would the house be oriented towards?
So,
And if you could state your name.
Abram Mitchell.
Okay.
The house will be oriented facing McKenna. One point I wanted to just bring up, because y'all were talking about the point of the contextual overlay. We've had the pleasure to kind of speak with some of the people that was part of the process of getting this overlay in place. And to my understanding and what was voiced to me, the point of the overlay was to eliminate tall and skinnies. If you could see up the street, those skinnies. So the point that we were making, if you look at this page, is the aesthetic of the home. So based off what we're allowed, it's going to be something aesthetically that looks like a tall and skinny.
Yeah, we basically just don't want the house to look like a shed in the backyard. We want it to align with the neighborhood. All the surrounding structures are anywhere from 1,100 to 2,000 square feet. So our footprint of 587 moving to 750, the home would only be about 1,200 square feet. So it'd actually still be smaller than the neighborhood average by a good bit. Our main concern is we just don't want the house to look like a shed. It would be the only house under a 600 footprint within a mile or two of there.
And one more thing, the placement of the lot does matter. So with it being a corner lot, although a corner lot is larger, we have more setbacks to deal with the corner lot. And also, depending on the placement of the property, like y'all were just talking about, that determines which homes that you use to calculate your square footage size. So if it was placed, let's say, next to those tall and skinnies, we would have a much larger footprint just because it's next to a larger home.
Thank you.
Ms. Johnson, to your question, I could not use I lost my cursor, but I could not use the lots east, these two, because they're not in the overlay. We can only use the lots within the overlay to calculate for the overlay.
I just also wanted to say, and either way the board votes, I understand it, but some of this is also because we're keeping an existing structure, which is also a choice. So I just, a lot of these were choices that are made, so I don't have a problem, it's entitled based off of the zoning, but when you're entitled to certain things, you also get some choices building design wise within that. And so a choice was made to keep the house, which is why now there's an ask to, to enlarge the square footage that they're entitled to based off the lot. So I think that that's something that I just wanted to, because if that house wasn't there, they probably could build two houses or a duplex that would fit within the setbacks, that would fit within and comply with the code without even a need for a variance.
Yeah, and this is the same thing we dealt with, I guess, maybe a few meetings ago where you have a, oh, sorry, yeah, the public meetings, I'm sorry.
We closed the
sorry.
public hearing.
This is the thing that drives me nuts about overlays sometimes is that, and this happened a few weeks ago, is you have parcels that aren't in it, you have parcels that are in it, and we're supposed to just, I understand the zoning administrator has to follow what it says, but to me, we're creating a sort of a wall with sort of a common sense component to this of looking at the surrounding area beyond just where the overlay sits versus where it doesn't sit.
I have a suggestion.
Yeah.
Because I don't know how this vote is going to go.
Sure.
And my suggestion is your council person wrote us a note that she's not in support, and I don't know why, it didn't say why. Some of your neighbors were not in support. My suggestion to you is because the contextual overlay is a community-driven tool, that you go to the neighbors that are in the contextual overlay and you have them sign a petition saying that they are in support of what you're doing. And that might, if you brought it back to us, that might get you some more yes votes. If you'd like to defer to another meeting.
We can reopen the public hearing to
Oh, yeah. I
ask
guess.
them about. It sounds like that might be advantageous to do a meeting or two deferral, to meet with the neighbors and the council member. Would a 2-meeting deferral work?
I mean, if we go get denied here, then of course.
Yeah.
The deferment would be a chance for you to come back. I will just say this from my position, because I know it will be more work for y'all to come back. Even if everybody agrees with this, I feel like I'm going to be adding another layer of legislation, because I'm going to be deciding, okay, this is the math on the contextual overlay, but because it doesn't seem to work out, then we're going to change it. I don't think I'm ever going to be comfortable with that. I'll just tell you, I'll rethink it. I will. I don't think it's a superimposing structure, but there is the contextual overlay, and it is just math. And I was thinking that, well, maybe there's some way. I was trying to stretch really, and thinking that, well, because it's a corner lot, maybe but that really isn't a hardship. So, I'll just tell you, I'm glad to, and I think some other board members minds are still open. I'm not telling you mine's totally closed, but just so that you're not coming back, that's where I am. I don't know if anybody else, because you got to have 4 votes.
And I think Member Kaepernick's suggestion is really good, because even though I've sounded like I'm against it, I'm open. Like, if you get neighborhood support and the council person, then it's like, then what are we fighting it for?
Yeah, and I think they've been here today and seen us talk about things like tree location and other sort of components to the property that might perhaps give them an opportunity to eliminate on their hardship with respect to the nature of the property, that they might take some of the.
And pictures are always good too,
Yeah.
of the context. Like, I think that helps too, to have pictures of the context, like
Right.
show what's behind you, because I do think that mattered to some of the members. Show what's up. I think all of those things matter and would definitely help, because I think right now.
Pictures of the street?
And just, because I think that context would help us see it too, and then get a better idea
Okay.
of what you guys are trying to accomplish.
Explore what is unique about the property that presents a hardship that justifies this, other than, it should be bigger because it won't be out of character with the neighborhood. That's what I think I would.
Understood.
I think
Keep
you're
an open mind about it.
I think you're hearing people liking the look and the feel of this structure and the way it fits, but we have to look at the actual land and the property itself as a part of that. So that's an important consideration.
So, can I
So
speak real quick?
if I may suggest, what would be good is involve a council member because it is community-driven, contextual overlay. And a council member literally stated oppose. However, she did not state the reason. So if you would reach out to the council member and ask to convince community, this is indeed a corner lot and indeed duplex eligibility lot. So when we posed a contextual overlay, we overlooked that negative impact. If you can come back with that, we may be comfortable with considering a hardship. However, without that community input and council members' input, I think we are in a tough spot because by agreeing with you, we are rewriting contextual overlay legislation, and which we don't want to do that. So that will be our suggestion to go back to the community, reach out to the council member, and then get approval, petition, or whatever. And so deferment will be advantage to your application.
May I say
I'll
something
move
real quick?
we defer. We still have the public hearing closed.
Oh,
I think you asked.
I think it was still opened.
Okay.
I don't know that we
I'm
actually,
fine.
yeah.
Does somebody have a question? I just don't want it to be.
No, you would just, you would
Yes,
ask.
sir. So
Could-
I guess, I guess you're right. We don't really have a true hardship. What we're looking at is we don't mind and can build the house with the 587 footprint. To be honest, financially, it doesn't really make a big difference for us because the smaller the house, the higher the square foot you sell for it. But we want to build something that fits. And building a house that's less than 600 footprint would look absolutely ridiculous. And I think it would actually be a disservice to the neighborhood to do that. So we're not asking for, we're not building a huge house. We're literally here to ask, can we make this better? If you deny us, then we're still going to build a house and it will look silly.
Yeah, we've had this come up before, and I think that Member Johnson's and Ms. Davis's both suggestions to engage your council member, I think would be well taken. So.
I have tried to.
You were the one. I'm sorry. I'm getting confused about who said what. My brain is tired.
I think there's some members who are willing to buy the corner lot argument as a hardship. Just show that, show the picture, show why. I think we just didn't have enough based off of what we had. Because I don't think anybody here is against what you guys are proposing. I just think you have to demonstrate within the law why we should do it. Does that make sense?
Yes.
Yep.
So I'll make a motion, we just defer this for 2 meetings.
Will that be on the?
August 15th.
August 15th, it's about a month.
1 month, so is there a second? All right, there's a motion, a second. Any further discussion? All in favor? Okay. We'll see you, you're deferred till that 2 more meetings.
August 15th.
August 15th.
August 15th
Yep.
here again?
Yes.
All right, perfect.
Thank y'all.
Appreciate y'all. Grab your sheets, Matthew.
Fantastic, really good use of that word.
Sorry, let's try it with microphone. Case 2024-94, Mr. Jimmy Pierce, 2950 Vaux Lane, requesting a variance in street setback
This is the, yeah, there we go.
to allow the construction of a second residence on the lot. Referred to the board under section 1740, 180 IDB variance request. I know there's no opposition present because the only gentleman in the room besides my 2 inspectors is the next applicant. So, guys, let me go through the slides first. This subject property is located on the corner here of Vaux Lane. You see the in this photograph, in this aerial, and I'll show you in another photograph, there's an in-ground pool sitting in the approximate location of this new structure would be going in that location. Just to your immediate east is an SP that, or MUL zoning, which has a setback less than, but 40 feet, which is what's required along Gale Lane. And the reason for this setback, this lot was subdivided after 1998, and corner lots that are subdivided after 1998, unlike the prior case or the fence case we talked about earlier, where their setback's 10 feet, this is actually what's required in the book because it came after 98. So there's a 40-foot required setback here. They are proposing to do a 20-foot setback, and then this is the approximate footprint of the residence that they've submitted to us. And then this is a view. I'm sort of standing at the intersection looking. Just to my right is Gale Lane. Fox is running north-south to my left. That's the existing residence that's on the home. You saw that in-ground pool. The next photograph shows it better. Kind of a hillside there. And then views looking east. That MUL zone property, you see those structures. They're probably 20 feet or less off of Gale. And then an aerial photograph again of the subject vicinity. Okay, with that, I'll turn it over to you, gentlemen, if you'll state your names and addresses for the board and present your hardships.
Good afternoon, Board. I'm Jimmy Pierce, 2515 Brittany Drive, Nashville. This is Josh Driver.
4913 Bethesda Duplex Road, College Grove, Tennessee.
But he's actually the property owner for this location. And as Mr. Hargis said, we are trying to get a variance on reducing that setback and building a new structure there. And a couple of things to point out. It's kind of an odd-shaped lot, as you can see. So, we looked at different options with building another structure with the current setback. And, we think it'd be possible, but it would push it back, make an odd-shaped structure that just wouldn't fit the neighborhood. So with it being an odd shape, we're seeing that as a hardship. And then bringing that closer to Gale, we think it'll be more in line with the Gale Park development that's behind it. So.
Is Unit B going to be oriented towards Gale or towards Vol?
So,
and I'm always mispronouncing that.
Yeah, Vox. Yeah. So we talked to NDOT, and they would like the driveway coming off Vox.
Okay. Is the front of the house though going to be facing Vox, or is so like the front door and porch, are those going to be towards Vox as well?
Yeah. We would probably, so the structure that's there. I know there's no pictures for this, but it uses the corner where you've kind of got a corner porch. So we would probably use the corner for just aesthetics. But, front, sidewalk, mailbox, everything would be off Vox.
Yeah. By code, it has to face Vox.
Yeah. Okay, got it.
So where's the pool in the site plan that we've got up? Is that?
So that will be.
Pool would be taken out.
Taken out?
Yes, sir.
So you're not doing this because you're leaving the pool and you need more room?
No, that would be taken out.
The house will be on top of the pool.
Yeah,
That's right. Yeah.
I just wanted to confirm that.
Like where the pool is, not like with a pool that's like the, a basement pool that's,
We had thought about putting the house in the pool in the house, but it just didn't make sense to have that be the living space,
Okay, any further questions? All right.
Well, I had a couple.
Go ahead.
Can you go first if you don't mind?
Oh, sure. Yeah, I was gonna, I live pretty close to here, drive by it all the time. There's like a pretty decent slope from where the house currently sits down to Gale. Isn't that right? Okay.
Yes, sir.
Yeah.
Yeah, I mean, it's not a huge slope, but
Right.
there is a slope.
Would y'all have to do some sort of, okay, yeah, maybe I'm thinking of from where the fence is. Would y'all have to do a ton of grading or would it be something that y'all could do it without? My main concern is not creating too much more of a slope to where you're not going to create a runoff issue.
No, because, as where the pool is sitting, it's more level up there, and it levels out as you go towards Vox.
Okay.
So more of the slope is going to be where the fence is down to Gale, so we wouldn't disturb that area.
Okay, thanks.
And also sloping, or the pool, it was less of a slopage. Not sure that's a word, but it is now. But there, and then because of the pool, dirt was brought in. So once that's taken out, there's going to be, room to make it more flat.
Any more? Okay.
So what you have drawn, and if we could go back to the site plan, it seems like that's further behind a 20-foot setback that you're requesting. So why did you request a 20-foot setback? Seems like the front corner is maybe 27 feet.
Yeah, the thought there was just to give us more room to finalize our plan on, and it would, I think the platted setback maybe was 20 feet. So when talking over with our surveyor, he suggested maybe just taking it back to that.
Okay. And then there was a few opposition letters, and they were concerned with parking, and can you address how?
Yeah, so the neighbor, so you see the shared drive for the existing structure and the neighbor. They were concerned that drive would be used for the new structure, but it would not be. It would have its own driveway going off of Vox.
Yeah, and I've talked to the folks who sent that in, and the person who owns it said that that was their only thought, and I reassured them that that drive is not going to be used.
If I may, so you got tentative approval from NDOT of the curb cut side of the bollocks for the new driveway access?
Yes, and I've got that in an email that I can share with you guys.
Okay, if there are no further questions, we'll close, discuss. Well, it's clearly an odd-shaped lot, and I think if you're doing just rough geometry, they're almost meeting the setback. If you kind of follow how the property is cut, if it weren't an odd-shaped lot, they'd pretty much be meeting the setback. So I think it's kind of a obvious hardship to me that and they're not over asking. I mean, it pretty much corresponds to, again, using rough geometry to kind of how much of the lot was taken off, probably taken off at some point, I'm guessing, for Gale Lane, or it had to be set up that way because of Gale Lane. So I see a hardship, that's for sure, and I don't think there's any problem with welfare to the surrounding properties or anything else, so I'll make a motion, we approve it, yeah, based on the hardship of the shape of the lot, so.
I'll second.
Okay, there's a motion, a second, any further discussion? All in favor? Okay, that passes. All right, thank you, gentlemen. Sure, yeah, we've got one more, we'll take 5 minutes, and then, here, yeah, no problem, we've got, I think we just have one more.
Okay. Board will be in recess. Back to order, and I'll give Metro Nashville a few seconds to catch back up with us. Okay, the final case for today's agenda is case 2024-95, Urban Capital LLC, appellant and owner of the property at 6109 Robertson Avenue, requesting a side setback in RM 15-A-NS to construct multifamily residential development. There are no parties present in opposition. I'll go through the case. Let me pull up the presentation. Okay. The subject property is this RM15 strip of land that's located over in West Nashville. The adjoining parcels are zoned, my glasses. Well, I'll get you the adjoining zoning. Nonetheless, there's a landscape buffer required along both the eastern and western property lines. The nature of this request is requesting a side setback to reduce the side setback down from 10 feet to 5 feet on this lot. And give you a view of the subject lot. This existing residence will be raised. The gentleman's proposing to construct 3 units on the lot. And then these are views directly across the street. New construction that's happened on Robertson Avenue, and a view of the adjoining residence there, and a look west. Okay, I'll leave that up, and I'll get you the zoning of the adjoining properties here in just a second. With that, I'll turn it over to the gentleman at the table.
Thank you, Mr. Chairman and members of the board. I come before you.
Can you state your name and
I'm so
address for the
sorry.
record?
John Rankin, 1709 Woodland Street, East Nashville. We come before you. We bought, it's R8. It was R8 when we purchased the property, and I do believe the surrounding properties are also R8. It had a 5-foot side setback, and so do the ones that surround it. And we got it rezoned to this new zoning, and didn't realize that had one effect, and that is it increased the side setbacks from 5 feet to 10 feet, even though all the surrounding properties are 5 feet. And then when we started to design the project, we figured out, of course, and I've been to 3 total community meetings for this project.
So what was rezoned? Not this specific?
We rezoned this specific.
This
Yes, sir.
is a specific plan?
We rezoned the property from R8 to RM15ANS.
Just this lot?
Last year, just this lot. It's under under a new overlay, a new community character of MUN. It's mixed use. So all of this is purple in the CCM. Planning felt it was appropriate for RM15. We agreed to add sidewalks and NS, of course.
So the RM15 is a 10-foot side setback?
That's right.
Okay.
And we have a 50-foot lot. Our issue was and there's the purple. So when we start to design it, we have to face, and it was also important for the community that we have parking, that we face Robertson with our first structure. And once we do that and take away the side setbacks and the minimum drive aisle for the fire marshal, we're down to a very small, thin house. And our hardship is the combination of all of the issues related to RM15 on a 50-foot lot, including landscape buffer, which we'll have to maintain, fire marshal access, and
what did you get out of the RM15 zone?
Well, we're due to our zoning, and we should be allowed 4. So we're 25,000 square feet, which allows for 4 units. We're only asking for 3, so it's 1 more unit. Essentially the one in the back.
That was the advantage to rezoning to RM15.
Correct.
What were you limited to before you rezoned to
2 units,
Okay.
right, because we were a duplex zone R8.
So you by rezoning, you picked up the ability to build 2 more units, but you gave up the side setback.
1 more unit. Well, yes, picked up the ability to gain 2 more units. We're only asking for 1 more.
Right. But you gave up the side setback as
Right.
part of that. Okay.
Right. And so regardless, to have an RM15 zone, and have parking, of course, the problem is we're now A as well. And A requires that the parking be behind the structure. So we have to get in behind the house.
I get it, but weren't these kind of choices you made when you made the decision
Yes.
to go with RM15 because it allowed you to go
One more
more
unit.
units, but couldn't you foresee that you were boxing yourselves in other ways with these?
Well,
I mean, it seems like you kind of got the advantages of RM15, but there's some things you don't like about RM15 that you want you're now bringing before the BZA.
well, we're asking for a variance based on a hardship on the result of the side setbacks allowing us a 10-foot wide house. We have no other option. Like, there is not an alternative. We have to face, the house has to face Robertson.
The units have to face.
Face yes, and so we have no, if we had another option, we would not be here. That is, I would think, is the true definition of a hardship, that we have no other choice but to build a 10-foot wide house. And I don't know of one in the city.
Yeah, but if you just, well, I'll just say this. I mean,
Yes, sir.
Couldn't you'd be okay if you just built 2 units, right? You'd have couldn't you work the drive aisle where you could put 2 units in, or
How could I do that? All I'm allowed is 10 feet in the front. If I I have to park behind. So what I'm saying is the combination of everything, the fact that it's alternative zoning means I have to park behind the structure. I can't park in front. What you're saying is I could build a duplex, move the building back and park in front, but I can't now.
So you're really saying you could only do one
10-foot wide house.
One 10-foot wide house,
Or.
unless you got any kind of variance. I mean, you couldn't even go down to 2 without a variance.
Correct.
You'd be stuck at 1.
So.
Because of the requirement, again, that you have to have, the house has to be facing.
Robertson, and we have to park behind, and we have landscape buffers.
And you got the drive aisle consideration and landscape.
The fire marshal.
And those are all, the orientation towards Robertson, the parking and the landscape are all part of the community character overlay?
They're all part of the zoning.
Okay, right,
Yes.
okay. How does
Your thinking is I'm sorry, I didn't know.
Well, how does the character overlay play into this?
Well, it plays into it that we would expect that all the other adjoining properties would end up with a higher density zoning than as us.
Okay.
Meaning across the street the SP has a 0 side setback. And again, the serious thing we're saying is nothing about our 5-foot side setbacks is any different than all of the houses you see there. We're not asking for less than they have, we're asking for what they have.
And I get that. I think
It doesn't break the.
Yeah, I get that. We're always looking for a hardship, and legally, we have to find a
Sure.
hardship. So I think tell me if I'm wrong, I think what you're saying is, to build more than 1 unit, you'd have to have a variance. So if you're gonna build more than 1 unit and request a variance, you might as well utilize the back of the space and
Right.
go ahead and put in 3 units.
Correct. In this zoning, we have to park behind whatever structure we build. We're down to 10 feet now.
Are you required to have a 20-foot wide, where's the 20-foot wide drive requirement come from? Is it from the new zoning or
Fire marshal's access,
because you
Fire
have
access.
multiple units?
yes.
If you had 2 units, maybe this is a codes question. If you had 2 units, would you have to have 20 feet wide?
The 2 units, the code changes for us and it becomes a 12-foot drive aisle.
And once it goes to 3, it becomes 20?
Yes.
So that would give us 8 more for a duplex.
So if you had to have, if you had 1 unit, what would the drive aisle have to be?
12 feet.
12 feet?
Yep. Yeah, it's 12 for 1 and 2, and then when you
So
go
if you went to 12 feet, you could put 1 more unit in, but not 2 more units in.
Well, if we went to 12 feet, we could have an 18-foot duplex.
Say that again.
Well, if we went to 12 feet, we would get 8 more feet, right? We'd gain that
So you could put a duplex in.
for 8, with an 8.
So you'd have 2 units. essentially.
Correct. Which we had before.
So you're saying rather than do the duplex, you want to do these separate units, and then if you've got to go but you're going 20 feet to get to 3. You just need 12 for
2 units. Right.
Yeah.
So what I am saying, the hardship is that due to all of the considerations for the zoning and the width of the lot, we are unable to build. We're not even asking for the maximum number of units for this lot. We're unable to build 3 units, which is our right under the zoning, without having a 10-foot wide house. It doesn't seem like a rational.
Joey, are we able, I know that on certain things, planning weighs in. Are we able to request planning's input on this, to defer it maybe a meeting or two and ask for planning to, ask them to comment on it? Because, I mean, planning obviously.
I'm not sure planning can comment on variance requests.
Right, I've never seen
Okay.
them do that.
Yeah, I didn't know if they were, if they could.
No, I don't think they can,
So, I mean,
actually.
I'm with you about, here's what I'm struggling with. I don't see any unique feature or characteristic of the lot that's different from any other lot there. What I do see is you've got different zoning, and that's just not what we can't weigh in and say, well, because of the zoning, you're essentially saying kind of indirectly, the zoning code itself creates some hardships, and I'm really uncomfortable with that, and I think the other members probably are too. So, but I'm trying to keep an open mind here and educate myself about what, you could do 1 unit, you'd have to have 12 feet. You can do 2 units with 12 feet. So you could essentially, with 12 feet, you can get the 12 feet and you can do 2 units.
Correct.
There's no question about that. But how do you get, here's a question then, what is it seems like the 3rd unit is, I guess, what I'm struggling with. Because if you can get, under the current zoning, you can get 2 units in by making the 12-foot aisle and
Yeah, Mr. Chairman, I wanted to check on the side setbacks. If you go to 2 units, the side setbacks actually decrease. It's RM 15A and S. The chart says the setbacks would be 5 feet.
which is where he is now.
Yes.
No, I'm sorry, it's 10 feet.
Which I was before, yeah.
So is it the 3 units that's creating the 10
The
feet?
the 3rd unit moves it from chart A, which is 1 and 2 family dwellings, over to chart B, or chart D, excuse me.
The way I'm seeing this, the 3rd unit is what's creating your hardship.
Right.
That's what it comes down to.
Chairman,
That's, I think,
with that token, I think 3rd unit is creating the hardship because of the fire marshal requirement of wider driveway access.
Right, and also because it's increasing the setback requirement from 5 feet to 10 feet. So, I guess
Well, and that, I think to your, one thing that is intriguing to me is the fire marshal requirement a thing that creates, it feels like we're in a chicken or the egg scenario here because, the people who choose to rezone the property that would allow this, they were the ones who said, we will approve this rezoning to allow for up to 4 units. And so I think that it's one of those situations where they're the ones who decide how many units can go on the property, that they basically have said,
right,
this can sustain 4 units. And now we're in the position of, okay, now that they've said this can sustain 4 units, we are tasked with reviewing it in the context of 4 units can be on this property, I think. And so,
I don't know with the drive aisle of this.
I think that's the intent of the planning because the T4MU is higher density urban zoning area. So their intent is to increase density, and as a planning perspective, it would be appropriate area. And then when it comes to variation of the side setback or frontage or whatever the case of variance will be, so their decision come to our body. And the density portion was solved at the planning stage, and now we are asked to solve, is this variance appropriate for this particular property, for the safety requirement and so forth. So I think we are tasked with that difficult decision.
And the other thing
If I close the public hearing, by the way, so I
sorry.
want to make sure. Okay, yeah, so we can close the public hearing.
Well, and the thing that's interesting, because to me, and this is what, the table basically sets it, you know, if we have 2 units, the setbacks are smaller. But as we add a unit, we put more. I'm struggling to understand sort of what that actually does in terms of, you know, for the sort of context of the neighborhood, that, you know, we're looking at sort of a math equation that might actually do something, to me, that would be odd for the property if we said, okay, because we're adding a 3rd unit, we're getting narrower, but these units are sort of spaced in a manner that I just don't understand what benefit that would add.
Well, I don't think we have to understand, here's what I see is, I just don't see a hardship here. I mean, all I see is that there are certain zoning requirements that are constraining the appellant, and, I mean, the appellant can do whatever you can do without having a hardship under the zoning code, you're free to do, but I don't see any hardship identified with the shape of the land or anything that justifies a variance. I just don't see it. I mean, I understand his concerns. I respect the fact that he's trying to get density in a city that needs density, but, you know, if somebody else sees a hardship, to me, that's the first analysis, and I don't see it, but.
I agree with you, Mr. Chair. I don't see it. I get to say my favorite phrase. Certain horses, certain courses. That's it. Like, I just think it's one of those situations, and it's not our job to make things fit. And, like, we have to follow, like, your threshold question. Is there a variance? If there is, what are factors that we're looking at? And I haven't seen any. So.
And the thing that I struggle with, though, is planning made the determination that created his property right to be able to put 4 units on this lot. And now, because, you know, in exercising that right, it is going to require this 20-foot wide driveway. And so.
Well, the way I look at it is, what they said is, you can build up to 4 units if you can comply with the code. I just see it a different way. That's the way I see it is, you have the right to go up to 4 units, but you have to meet the drive aisle, you got to meet the setback. So.
Zoning changes don't imply compliance with the code. It's just saying, hey, if you want the zoning change and we can find within the policy that the zoning change is appropriate, we'll do it. But it doesn't mean that then, because we gave you the zoning change, you don't then have to comply with the zoning code. It's just, those things work in conjunction. And if you can't comply with it, then we don't have to approve it unless there's absent, if you show a hardship with the land, then we would approve it.
Yeah, I just struggle because I think in terms of lot coverage, that, you know, he's permitted to do what's been authorized under the rezoning. The number of units are permitted, and so what is getting in the way now is this drive aisle, and I think the lot is, for what it has been rezoned to allow to happen here, it is really narrow. I mean, it is a very narrow and shallow lot, and so I think it's a weird thing that, and maybe I'm getting over lawyering this, which happens all the time. Is, you know, he's had an agency that says this is suitable for this, and now the question is, has that put him in a position to where he can't do that, what he has been given the right to do, because of how deep and skinny this lot is. So, I don't know.
I think there were some choices here, the rezoning, the 3rd home. I think there's a remedy, which would be SP zoning. That would go to planning. That's where it should be. Probably shouldn't be here, though I understand the attempt. But I was wondering if you would like to make a motion, just because we won't see you for a while.
I'll make a motion that we deny the request because a hardship hasn't been shown, therefore not justifying the variance.
I'll second since I asked you.
Okay, there's a motion, a second. Any discussion? All in favor of the motion? Sorry, thank you for your time. Okay,
Did you
I think
ask for
that's,
any opposed? It wouldn't look like a unanimous vote to me unless, did you have your,
Yeah, nobody asked for opposed.
Right.
oh, I'm sorry. I thought you had your hand up, so, okay, he opposes. Okay, I'm sorry. Thank you for catching that. I glanced to the right and I thought,
Let the record reflect 4-1.
okay, 4-1, okay. Yeah, thank you, sir. Motion to adjourn. Okay, all in favor?
I oppose, I'm just kidding.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.